Fresh appeal. Fresh appeal. Fresh appeal tomorrow.
My lord, fresh clearance, my lord, on the ground of compromise. Question the proceeding.
Give it. We will see. Huh?
My lord.
Give it.
My lord, the case restoration by the Hon'Ble High Court of Orissa, 26 June 2024.
You are appearing in person or
Sorry?
you are appearing in person?
In
Okay.
person.
Okay.
Yes, in person. From date to I have been submitting the mention memo for next hearing, but not.
What is your matter?
10 times I submitted, 4 times before this Hon'Ble.
It's all right, but what is there may not be urgency, therefore it's not listed. What is the urgency?
Urgency, this is a criminal matter. There is a chances of loss of life.
So what are you asking in this petition?
I am asking the arrest the accused person who were undertaking the police station, but police station police personnel are submitting the report, that final report. When the criminal
You tell in Oria, no problem.
revision,
You tell in Oria.
revision case was proceeding before the district judge. They
नहीं
not-
एई केस रे आपण कोन मागुचंती?
reliefs are suspension order against the police personnel, submit the charge sheet.
Oh, ताई urgency कोन अछि?
Sorry?
Urgency कोन अछि? Police investigation करके charge sheet file करती हो?
Final report, sir.
Final report कला पर आपण protest petition file करिवे?
Ban in any case.
Anyway, आपण दियो personally check it. मते देखेबो. दियो. Time waste करिया.
Petitioner is in NRI. The informant gave a missed call to the petitioner and filed here one case that he has scolded me in filthy language, 506.
Who has given this?
Informant has given missed call to the petitioner who is staying at USA.
He is the accused. Petitioner
Yes.
is the accused.
Yes.
Okay.
Now here he has filed FIR that
What is the imminent problem for you? You are saying
I was unable to come, my lord.
Huh?
I was unable to come.
Okay, we'll see. That's not a very apparent. This thing.
Passment pay, okay.
Okay, we'll see.
My lord, one.
Give it. We'll see. Because our regular court master is not there. I'll
Yes,
just check it up. Okay.
My lord, compromise matter.
Give it. Compromise matter. लिख दियो ऊपर compromise. ऊपर लिख दियो compromise.
Proceed on CRLMC. The urgency is 311 petitions filed by the accused is rejected on the ground that informant has not been cross-examined, for which we have filed 311 petitions which is rejected.
Write down at the top 311 and give it. 311 and give it. 311 CRPC application. So that it will be easier for to understand. Okay. Give it. Yes.
My lord,
It replies.
item 17, adjourn. Next.
1 minute.
My lord, 11,251 time matter.
Bail. Give bail matters will come. Give the memo. Give the memo. Give the memo. Bail matters will come. Yes. Page wise I'll call. Huh? Page wise I'll call. Yes.
Page 1. I don't want to tell.
1 to 10. Yes.
Item 6, my lord. Kindly next week, my lord.
Item
6, my lord. Compromise matter, my lord. Kindly next week.
next week may not be possible. If fresh matter, if you are asking for adjournment, it will go to February only.
Compromise matter, my lord.
Compromise. What are the offences?
My lord, 307, my lord. Simple
307. What are the injuries?
simple injury, my lord.
Head injury.
My lord.
देखिए लगा दियो December January first week first week January. Yes. Yes. First week January.
My lord.
Before that it's not possible. Yes.
Item 3, lordship.
Item 3.
Lordship.
Yes.
Pray for adjourn, my lordship. Next week, please.
On request adjourn. February. Yes.
Item 8,
8. Again, it will go to February only. February. First week or second week of February. On request. Yes.
Page 2, item 11 to 23.
14. 1-4. Yes. I told you it will go to February only. I can't help it. No, January was last week of January. Yes.
My lord,
Item 19, my lord. Kindly take 1 week after.
Don't say 1 week. I told you. It'll go to February and maximum January
January last.
last week of January. देखी दीजिए.
My lord,
Obliged.
17. 17.
17. Yes, madam. 17. What do you want? Adjournment. Same
Adjournment
story. January last week.
My lord, item 22, my lord, petitioner is the husband, my lord, opposite party, my lord, opposite party, two is a wife, my lord. Lordship, the matter has been compromised, my lord. Lordship can take up next week, maybe compromise, my lord.
What are the offenses?
My lord,
Offense.
it was a maintenance matter, my lord. Maintenance matter, my lord.
Maintenance matter. You have compromised.
Maybe compromise, my lord. 125 minutes.
You have compromised.
Maybe compromise.
Bring her tomorrow.
Compromise चालले discussion चालचे compromise.
Have you compromised with your wife?
My lord.
Bring her. Online, you bring her. I'll go. Allow it.
Today not possible, lordship can.
Okay, next week. Huh? Next week. Next week. If 1 minute. Next week is. 6th is 6th. 6th. Yes.
My lord.
Case 3, item 24 to 37.
Yes. Next.
Case 4, item number 38 to 45.
Item number 45 years, she may pay, no instruction.
45.
Actually, it's arising out of a cross appeal in the second appeal. Cross appeal I have filed. In the second appeal, I am respondent number 4. At the same time, after receiving the notice, I had filed the cross appeal. There was some delay. So last date I could not remain.
46, na?
45. That is our CM appeal. But I will contact this RSL on merit.
No instruction.
No instruction. So for CM appeal.
Thick.
Case 5, item number 46 to 51.
May I please, Your Lordship? Item 50, Your Lordship.
50?
50, Your Lordship.
Yes.
On behalf of Mr. Islal and Mr. Nanda, sir,
Just see 2008 matter.
my lord, kindly take it up Monday or Tuesday.
No, Monday, Tuesday. What is this matter? Let us see.
There on accommodation.
I'll take it up at its own turn.
On Monday.
2008 matter. You are enjoying this say.
Only Monday, Your Lordship. Today they have some.
No, Monday means I can't adjust the list like this.
I prefer.
So difficult. Anyway, we'll see. At the turn, I'll just see. I'll accommodate you, but in what way I can accommodate later. Yes. That is done. Next,
Case number 6, item number 52 to 59.
52 to 59.
Case number 7,
Yes.
item number 1.
Item 1. Nobody there. Pass over. Yes.
Item 2.
2 minutes, please, my lord.
Yes, madam.
This matter has to be placed before some other bench, my lords, because my lords, before elevation was appearing for the opposite party number 2 before the Honorable Supreme Court, my lords.
1 minute. Who was I was appearing?
Yes, my lord.
Okay. Leave the matter before some other bench where I am not the party. Subject to permission. Yes.
Deeply appreciated.
Item number 4.
Pass over.
Item number 5.
Need please, Your Lordship. The present petitioner is the wife, and being the informant had lodged an affair and seeking quashment of the same. As they have settled out the dispute among themselves, matrimonial dispute, Your Lordship.
You are the informant.
Yes, Your Lordship. I am also the petitioner in this present application.
And who is the accused?
In-laws, Your Lordship. I am staying with my in-laws as well.
But where are they?
Your Lordship, I have not made one party.
Then? Why are you doing this? You have to implead them.
Yes, Your Lordship.
You implead them and bring them.
Yes, I'll bring them. Your Lordship may give me a date. I'll bring them.
The petitioner is the informant in FIR number so and so and for alleged commission of offence under section so and so so and so so and so. See the counsel for the petitioner submits that she has settled the dispute with her in-laws and resumed her marital life. marital life. Therefore, she has filed this petition for quashing. However, the accused persons have not been included as the parties to this proceeding, and she seek permission to implead all the accused persons as opposite party. Let him do so by tomorrow. Release the matter. Tuesday, Wednesday.
Little longer date, your lordship, for that.
Longer date. Okay. Second December. Second December.
For the stay can be.
No.
Second December.
In 2nd December, you do if filing incomplete petition. You want to stay.
No, sir.
Bring them. I'll quash tomorrow. Also, I am ready to do it.
The person has to
do it.
Obliged.
Yes. Adversarial.
May I please, your lordship? Lordship, quashing of FIR on the ground of compromise, my lord. But the petitioner number 1 is an out of station, so that he cannot able to appear the court. Another date maybe, so that
What are the offences?
offenses 294, 323, 34, 342, and 340.
Investigation is still going on.
Yes, ma'am.
Huh?
They are both in broadband, my lord, meaning each broadband.
Each other.
Man, compromise is it.
Compromise, but see, I can't wait for the accused like this.
ଝିଅର ବାହାଘର ତ ସେ ବାହାରକୁ ପଳେଇଛନ୍ତି ତ ସେଥିପାଇଁ ଆସିପାରୁନି ସଡନ ଜୁଲାଇ ମାସରେ ଫାଇଲ ହେଲାଣି ଆଜି ନିଶ୍ଚିତ ହେଇପାରୁନଥିଲା ତ
Okay, make it on 3rd December. 3rd December.
ଥାର୍ଡ ଡିସେମ୍ବର
Then?
Merit କିଛି ନାହିଁ except the compromise.
କମ୍ପରମାଇଜ
Compromise କାହିଁ ଆପଣ ଆଣୁନାହାନ୍ତି?
ଡିସେମ୍ବର ଲାଷ୍ଟ ୱିକ୍
16th of
During vacation you want.
we committee 16th of December.
18th December.
Right.
18th December. Yes.
I am straight up.
ଭାଇ ଆପଣ ଆଣିବେ ତ ସର
No, it's next.
Item 9.
ପାସପୋର୍ଟ ମରଣ ପଇସା
First.
This is a compromise matter.
Password.
Compromise.
Compromise ହେଇଯିବା
Nine. Compromise.
No, the party in hand. State is not a party.
State
Both
not
are
a party.
lordship. Both the parties have come up.
133 CRPC.
Yes, lordship.
It's settled very school.
Yes, lordship.
Shall I close it?
Yes,
Yes, lordship. Both the parties are also there before your lordship.
Who has initiated? Where is 133? Who has initiated?
My lord, I am the informant. I had initiated the 133
First party.
proceeding.
You are the first party.
My lord, my lord.
You are the opposite party
I am
number.
the opposite party, my lord.
Yes. At the instance of opposite party, sole opposite party, the proceeding under section 133 CRPC was initiated against the petitioner in what is this number? In
In
CP3. CP3 case number 158 of 2019. The parties have now settled their dispute. And where is the affidavit? Anything you
Yes, sir.
filed?
Should over that.
Parties have settled their dispute. And on the basis of the settlement, the present petitioner is seeking quashing of the entire proceeding. The opposite party number who has filed, the parties have filed joint affidavit dated joint affidavit dated 29/11/2024 inter alia stating as under for para 3, 4. To 12. 4 to 12. It's very well drafted affidavit. This is how the affidavits are to be done. Compromise it, exhaustive petition. They give it to the other junior counsel those who are filing. It's fantastically drafted. Yes. 3 to 12. Regarding the parties are there.
Yes, sir.
The petitioner and opposite party number 2 are sole opposite party. Opposite party. are present in the court being represented by the respective counsel and identified by them. They have also filed self-attested copies of their Aadhaar card to establish their identity. Regarding head to the terms of settlement and the party and the affidavit joint affidavit placed on record, I'm inclined to allow this petition. Accordingly, the ICC case number triple
The CP
case number 158 of 2009 is quashed. Yes,
Obliged.
is dropped.
Item 10.
My lord, just a small correction. My lord, that
Disposed
criminal
of.
revision is under challenge in the CRLM. My lord. That
Both are disposed of. All are
both
disposed.
disposed.
No, what have you challenged?
Here, criminal revision, my lord.
1 minute. Criminal revision.
The order that was passed therein, it was
Criminal revision number 8 of
Impugn
2021.
impugn order dated so and so.
Yes.
Impugn order
Dated
29/7/2024 passed by the Sessions Judge Angul in Criminal Revision 8 of 2021 is quashed, and as a consequence, the proceeding initiated by the opposite party against the present petitioner in CP3, case number 158 of 2019 is also dropped.
Right.
Yes.
Obliged.
Item 10.
Can I prefer pass over rulers?
Pass over. 11.
Item 11.
I pray for passover, my lord.
Nice. 12.
Item 12.
Please, Lordship. If the Your Lordship, here the present petitioner has filed this present application in where his application filed under 311 petition was rejected. Lordship, pardon, Lordship, I have not filed the impugn order. I am filing through.
Except impugn order, you file everything.
Missed out. Inadvertently, it was missed out, Your Lordship.
Have you filed it in the registry?
Yes, Your Lordship.
Yes. Yes.
I had paid for.
PW6.
Yes, Lordship.
Where is the charge sheet? What are the offenses?
Your Lordship.
Only 376.
363, 363.
POCSO is not there. Is there? Then that's the problem. Where is her statement? The girl's statement? Deposition, yes. Victim. You have extensively cross-examined. You have extensively cross-examined. Where is the application under section 311? Yes. What are the questions you want to ask? Let us see. See, what are these questions? Can you ask this question? Just question number 3, just read.
No, better amendments they will take and file the petition also. Just to get the details of the birth date, Your Lordship, they want to re-examine it.
See, none of the questions are relevant, and rather these are very
Yes, sir.
derogatory questions.
Yes, sir.
You are going to ask the minor girl that you had any sexual relationship with
Your
anyone
Lordship, basically,
in your life.
we are saying that she might not.
For that, you want the minor witness to come to witness box once again. See, this is the questions you are going to ask.
Lordship.
And there is a bar also. There is a legal bar. That is the reason the legal bar is there in the act. because to humiliate the minor girl. You can't traumatize the girl by asking these questions. So therefore, it's rightly rejected. Rightly rejected. Rightly rejected, sir. I'm not going to right now. Petition is rejected by the order dated 17/8/2024, passed by the learned ADJ cum special court under POCSO at Jagat Singhpur, whereby his application under section 311 CRPC for recalling the PW6, that is the victim girl, for further cross-examination has been done down. The petitioner has petitioner moved the application under 311 CRPC. CRPC in the said application, the proposed question to be put to the victim girl is enumerated. I have gone through the 9 questions proposed to be put to the witness to sought to be recalled. These questions are completely irrelevant and rather aiming at humiliating the victim girl. Therefore, the petitioner cannot be allowed to further cross-examine the victim girl. Moreover, the victim was examined as a PW6 on 17th July 2024, and the petitioner, being an accused, was allowed to extensively cross-examine her. The questions proposed, couple of questions proposed to be put to the said witnesses has already been put to the said witnesses while she was subjected to cross-examination. Moreover, the trial court has rightly rejected the prayer made by the petitioner under section 311 CRPC by relying upon the statutory provisions contained under section 33(5) of POCSO Act 2012. I find no infirmity in the notice, and the petition is disposed. Yes.
Item number 13. I think it may be adjourned.
What is this matter?
Challenging the order of cognizance and consequential proceeding against the petitioner.
95.
Let us see if you have any merit, then I'll entertain. Otherwise, I'll give you liberty to move appropriate application. I'll tell you.
Here, my lord, as per FIR, my lord,
Yes.
but FIR registered against 3 persons, and it is registered under section 392(25) PAMS Act. Subsequently, charge sheet has been submitted against 2 persons under section 395 and 25(27) ARMS Act. Here, investigation kept open under section 173(8), my lord, against the petitioner, my lord.
Cognizance has already been taken.
Cognizance has been taken.
So it will raise all these points before the court below. 170, the case is open for 173 meeting. You people are on bail.
No, man, not bail, man. Investigation kept open.
Then you have, see, the summons have been issued to appear on 12/12/2022. You didn't go.
Page 21 le lekha hai ji, hence
22.
accused person is forwarded and bail by court as per BA number so and so by ADJ cum social judge vigilance.
You are on bail.
Your lordship, here is the Nirmal Das is not the prisoner in this case. In this impugned order, annexure 3 re Ratikanta Pradhan and Nisikanta Devi is bail agent.
But what is the stage now?
As per the conference statement, the name of present prisoner is entangled in this case, your lordship. Based on the conference statement, the accused, co-accused. Now, present prisoner is not in bail, your lordship.
I understand what is the stage now. October 2022, cognizance is taken.
Taken, right, your lordship.
What is the stage?
There's only cognizance has been taken thereafter. No proceeding.
Nothing. You raise all these points. Petitioner has assailed the order dated 26/10/2022, whereby cognizance of offenses punishable under section 395 IPC, section 25 and 27 of Arms Act has been taken against the petitioner. The further investigation in the present case has been kept open under section 171 with CRPC. The petitioner, although was summoned to appear before the court, but the petitioner has not appeared. Rather, belatedly.
Petition not summoned.
Those who were bail
Not summoned.
in that
No,
bail
no,
application.
someone got you. The petitioner has not appeared before the court and shown to he is absconding. At this stage of taking cognizance, I am not inclined to entertain this petition. However, liberty is granted to the petitioner to raise all the points before the trial court.
My lord, cognizance not taken against the petitioners, my lord.
Huh?
Cognizance not taken against the petitioner.
What is this?
Cognizance taken against two
Two
persons.
persons.
Those, my lord, charge sheet has been submitted against them.
What are you telling me?
I am telling you 173(8) investigation kept upon.
Okay.
That is under challenge.
That you can't do. That is right.
During investigation, is the
No, record. Cut the word. Petitioner is agreed by the order dated 26/10/2022, whereby cognizance of offences punishable under section 395 IPC read with 25 and 27 of Arms Act has been taken against
Ratikanta Pradhan and
against one Ratikant against the co-accused Ratikant Pradhan and
Nisikant Deuri.
Deuri. He is aggrieved because the trial court has kept the investigation open under section 173 with the CRPC. The petitioner has been absconding and apprehending arrest in the present case. Therefore, he seeks indulgence of this court for closing further investigation. I am not inclined to entertain this petition because this court, while exercising jurisdiction under 482 CRPC, cannot hinder of the ongoing further investigation. Hence, this petition deserves no merit. Accordingly, dispatched. Yes.
I mean, first of second of.
I don't know whether you are accused or not. 173(8) is open, and you want that 173 further investigation should be stopped. Can in a 482 court can stop investigation? If you are an accused, I can understand. You never know whether you are accused. You may be accused. You may not be accused. Till today, you are not an accused.
On the basis of proactive statement,
Maybe
police apprehending.
after investigation, they may drop it also. They may file it also. I don't know.
It will not drop.
So
It will still know very well. It will
What,
continue.
what to do? Yes.
Item 15.
Rather, you should go for anticipatory bail.
Anticipatory offense.
Saying that there is nothing, you get anticipatory bail.
Anticipatory is rejected.
That's it.
People are saying for him to be first or second or third.
No, I can't do it because you are not an accused today. Yes.
Okay.
Yes.
In this case, I am challenging the proceeding against the present petitioner.
Anticipatory bail application made by the petitioner has also been rejected. Yes.
Yes,
sir.
Petitioner is a army personnel. Quarrel between two villages. I was absent. I was appearing +3 exam on current date is 21 March 2016. On
Yes.
that date, I am appearing +3 exam.
Yes.
Annexure. The certificate is Annexure 6.
Yes.
Certificate by the principal. It is certified that Suresh Kumar Vishwala, bearing roll number such and such.
What's the time of incident?
21/3/2016 is the date of incident.
Time.
Time will also is mentioned at 3:48 hours. दिन 3:48 again.
Occurrence, Jesse, column 3. Don't read. 11 o'clock.
Sorry, 11 o'clock.
11 o'clock.
11:20, Your Lordship.
11 to 11:15. Show me when, where is the examination?
Annexure 6.
6.
The certified.
Yes.
This is certified that Suresh Kumar Vishal bearing such roll number such and such. University roll number such and such. Appear +3 second year university back examination.
What time? Exam?
Exam normal.
Normal, abnormal, I don't know.
Admit cut, Your Lordship, page 29.
The incident is taken place at 11 o'clock. That's what the report is. You might be appearing in examination. First of all, plea of alibi can only be tested because it's a question of fact to be tested in the trial court.
Boss
In the trial only.
at 40 kilometers or distance.
Whatever, these are the factual disputes. It has to be evaluated during the trial.
The 40 kilometer distance.
Maybe, I don't know. Maybe I don't know whether you are there or not. On the plea of alibi, it can't be required.
FR be amo na nahi. Mona could mention hen FR.
Charge sheet has been filed?
Charge sheet open ach. Charge sheet open ach.
Opponent was present person is alleged in accused number 5 in page 20.
Cognizance or 5.
Page 20, accused number 5, Suresh Kumar Vishal, present prisoner also.
20.
Yes, Your Lordship.
Yes.
Internal page of 4 of the serial number 5.
5.
2, 3, 4, and 5. 5. Suresh Kumar Vishal.
FR none.
FR in other.
Yes. FR.
FR none.
Yes.
161 रे भी कहना किछि कहना.
Yes.
खाली जे तुम से विलेज रो पर्सन सब विश्वास फैमिली
I
समस्त
know.
उठा.
What to do? Yes. Tell me anything else? Except plea of alibi, do you have anything?
One annexure 7, my lord. This is
7.
promotion.
What is promotion?
The departmental promotion. It is submitted that.
How many accused are there in this case?
His Lordship, FR column 68, Your Lordship.
68 arrest agent.
68.
Arrest agent.
Just see if anything can be done. He is working.
Your Lordship, that part I have gone through.
Because it seems entire village is made accused in this. And writing and all, huh?
436 and 360.
I'll just simply issue notice. Just see, check it up. If anything can be done,
Yes, Your Lordship.
we'll try and because he is working in defense. Defense? Defense.
Lordship.
He might have come to say you are working in defense. You are saying you are sitting in the clause 3 examination. I don't know what you are doing. And you came in the vacation, it seems you indulge in all these things. That's the reality.
Actually, I have not involved anyway, my lord.
What to do? Just check it up. Can he be helped or not? Just
Yes, Your Lordship.
find out the way.
One thing is that
The other
my
soul
current
charge sheet
is
is
not,
not-
added the
You don't have a case on merit. We are trying to sympathetically
Yes, sir.
consider. Don't argue on merit, sir. Then I'll dismiss it straight away. Yes.
the informant not as added as a party in this case. Your Lordship.
I'm just issuing notice. Just
I will-
examine it and tell me.
Yes,
so
what
that
is the specific role
if-
played by the present prisoner?
if we can take him out.
Yes, exonerate ହେଇପାରିବେ Your Lordship.
Because in these type of cases,
ହଉଛି
ultimately end up in acquittal. But at the same time, he'll lose his job.
Specifically gone through the
So therefore,
diary, therefore.
just see the call for the record and just see what
Yes,
way
sir,
we can
specific role.
simply issue notice. That's all. Yes. Next.
Item 16.
Withdraw. Okay. Sorry?
On behalf of both sides.
For
Opposite party. not-
opposite party. Opposite party evidence already. Yes.
Item 18.
There is a connected matter CRLMC 918/2019, which is arising out of same matter and filed by a co-accused person. So this present CRLMC may be tagged up with that.
Now, what is this here?
This is about cognizance of proceeding, arising about 420 case, my lord.
Yes.
So, my lord, it is stayed that other CRLMC, it is stayed. So, my lord, it may be tagged.
Show me the order.
But I don't have the order, but it was listed on 12/9/24.
Get the order. I'm passing it over. Get the order. First of all, you have written Republic. Republic, you need not write anyway, but get that order. Just
Yes,
see.
madam.
Yes.
Item 20.
18.
Get that order.
Yes, madam. Item 2. Kindly take one of two more.
Not tomorrow. Now you
Lordship.
tell me tomorrow. Why? Go to March.
No, Lordship, tomorrow.
No. Yes. What is
Brief.
this? What is this case?
Tomorrow, the Lordship, tomorrow. Kindly
Tomorrow may not be possible. I have kept some regular matter tomorrow.
Monday.
Not Monday. Not according to your convenience, ma'am.
Lordship,
Just see how difficult to adjust the
brief
list, you know.
today, the brief is not.
You have
With
some
me,
problem, you
Lordship,
tell, I'll take it
that
up
is
in
the problem.
February. What to do? I have listed limited matter today because so that I can hear some matters.
Next.
What is this matter? Let us understand first.
Oh, brief.
If you have merits, then I'll keep it. If you don't have merit, I'll dispose it. Let us see. What is this
My-
case? Will allow the application.
My brief is not me. but
27/4/2024. Where is the impugn order? Why you are always prepared? Why are you asking time today?
Brief with not me, let me say.
Please first
Not possible.
first week of January. First week of January. Okay. On request. Yes, next.
Item 21.
Item 21, my lord. Matter relating to domestic violence, my lord. I am challenging the order dated,
Annexure 5.
yes, my lord,
Yes.
26/2024.
Copy may be served on us, copy, no copy. has been-
And let us see what is this case.
Passed by the
Section
Lawrence
12
Municipal
protection. Oh,
Domestic
deviate.
Violence case.
Yes, how are you agreed, sir?
And the petitioner is a landless person implicated in a domestic violence case. Apart from that, there a civil suit.
What are the directions?
Direction by payment implement as 8,000 per month. 6,000 for
6,000
for agreed person maintenance and 2,000 for rent. I have annexed page number 34.
what are the areas?
There is no, I have not any payment in DB case manner. I have payment in Hamilport divorce case. I have paid 20,000. I have not paid any amount in DB case manner.
Divorce case is going on.
Yes, madam.
And any other direction for maintenance?
Only
125?
family court maintenance for 3,000 per month.
Hmm.
But London magistrate directed for 8,000 per month. The landless person. I have annexed page item. Kindly see the item page 34. Only page 34. Annexure 4 is.
34.
He has got a land under Rule 5(2) of OGLS Rules 983. Government wasteland. Both are joint property, my lord. Husband wife.
That apart from property, you must be doing something.
And there is a civil dues is pending regarding this land.
That is land is not only the only thing. You must be working somewhere.
I am working.
You cannot have landed property.
I am working in a temple, my lord, as a sebath. And as for the assessed liabilities, his monthly income is 7,500. Assessed liabilities he pays. Assessed liability pays, my lord. Page 24. Monthly income is.
Well, I'll issue notice, but subject to you keep on paying till the decision of this matter. Keep on paying the maintenance. I'll just see. Issue notice to the opposite party. Written also. Subject to petitioner paying. Is there any execution petition?
There is a.
No, subject to complying. The direction number 2. Direction number 2 of the impugn order dated 22/2/2024. The operation of the impugn order is stayed till next date of hearing. At least you pay.
Yes, yes, my lord. I have already paid in family court, but it is too difficult in another court.
Anyway, I have stayed the impugn order subject to paying, subject to complying direction number 2. Yes.
My lord, register push the
Yes,
issue.
Yes.
Item 23.
Present petitioner is the complainant before your lordship. My lord, the present petitioner challenges the cognizance taken by GMFC against two accused person, opposite party number 8 and opposite party number 9, wherein the initial complaint was filed making all the opposite party number as accused.
Yes.
My lord, the signature of the present petitioner has been forged and the credit has been enhanced by forging the signature of the present complainant.
The charge sheet has been filed. Charge sheet
Yes,
filed
your
against
lordship.
whom?
Charge sheet.
Page 52 it starts.
No, that's right. Charge sheet filed against how many persons?
Two.
Two.
accused
Cost
persons.
is taken against the 2.
My lord, initially the complaint FIR has been drawn against, filed against all the accused persons.
Then you have a remedy, sir. You have to file a protest petition against those
My lord,
against whom final form has been filed.
informant has not been informed
Now
according to
you know the remedy.
173 of the CRPC.
Now you know the remedy.
If I may assist one.
Yes, yes.
My lord, the entire issue before your lordship is that once the a report has been submitted by the IO stating that there is no case made out against 7 accused persons. So it was, your lordship knows the decision of the Honorable Supreme Court in Bhagwan Singh versus Commissioner of Police reported in AR 1985 Supreme Court page 285. The Honorable Supreme Court stressed the desirability of intimation to the informant. Our entire case is, my lord,
It's not informed.
no notice to the informant.
Show me that proceeding.
I'll take your lordships to page 69, my lords.
69.
Yes, my lords.
Yes. This is the first proceeding.
This is the first proceeding. My lord. The charge sheet has been submitted on 18/2/2024. 18th of February 2024. The very next day, the record was put up before the learned magistrate, and the same day the cognizance has been taken, and that too, your lordship may kindly appreciate, cognizance has been taken against a dead person. Ma'am. Although in the charge sheet it has been specifically stated that one of out of the 2 accused persons, one is dead, my lord.
Who is dead?
My lord, opposite part number means Abhinas Manti.
He died.
He has died.
What I'll do is I'll set aside this impugn order, the cognizance order, and give them opportunity to resort to the remedy under law, in the sense they will file protest petition. Thereafter, after the protest petition, the cognizance court can take it. And he says that one of the accused has already died also. It's a completely non-application of my table.
Rule 181 has also not been complied.
Show me from the charge sheet that this.
I'll take your lordships to page 52.
50?
Page 52. I've annexed the entire copy of the charge sheet.
No.
The report stating that the Abhinas Manti is dead.
Where is that?
Page 53, my lords.
53. Yes. 53. Yes.
So, Satri will lekhi list specifically.
Where is that?
Top, my lord. Abhinas Manti charge abated, my lords. Abated, my lords.
Yes. What is this? He is taken cognizance against the right petitioner. Petitioner is the informant in the FIR number so and so. In the FIR, the petitioner has made allegation against as many as how many accused?
9 accused.
9 accused. Specific allegation against 9 accused. After investigation, the police had filed the charge sheet on 18/2/2024, exonerating 7 accused, and the charge sheet was filed against 2 accused persons, namely against opposite party number
2 to 7, my lords.
No, exonerated.
Exonerated, opposite party number 2 to 6.
Seven accused persons,
2 to 7.
namely opposite party number 2 to 7. However, taken cognizance against opposite party number 8 and 9.
My lords.
8 and 9.
Yes.
8 and 9. In the charge sheet, in the last paragraph of the charge sheet, it is also mentioned that the opposite party number 9, 9 against whom the cognizance has been taken has already expired. Expired. The trial court, by the order dated 19/2/2024, has taken cognizance against opposite party number 8 and 9. 8 and 9. The counsel for the petition believes that as per the citation, as per the law laid down by
My lords, AIR 1985 Supreme
give
Court.
it in writing.
Yes, my lords. May I supply a copy?
It is inevitable under law. Law that the trial court ought to have issued notice to the complainant when they afford an opportunity for resorting to the remedy for filing a protest petition against the accused persons against whom no charge sheet is filed. Moreover, the imbue order acts complete non-application of mine because despite the fact that the police has filed, despite the fact that the police in the charge sheet have specifically mentioned that the accused Avinash Mohanty has expired, the trial court has taken cognizance against the dead person. In next problem, taking into consideration the aforementioned, I'm of the view that the imbue order dated 19/2/2024 is a culmination of a complete non-application of mine. Hence, the same is set aside. Petitioner is given liberty to resort to the remedy available to him under law for filing protest petition as against the accused persons, those who have been exonerated by the police, and the trial court is happy to proceed with the matter in accordance with the law. Yes.
Item number 24. I am seeking passing of FIR. At this stage of investigation, I have come, Lord. I am seeking passing of FIR. Lord,
Passing of what?
FIR.
Okay.
Lordship, last occasion.
Let me ask you. Let me argue, you will have your subject.
This all,
Lord, I am only on simple ground that on plain reading of FIR, no case as has been stated in the FIR is made out against the petitioner. That's the only point of mine.
yes.
If a Lordship see, I have prepared.
What is the status, by the way?
Statutory investigation is still alive.
Still going on.
Going on.
Yes.
Lord, on plain reading of FIR,
Hmm.
kindly see, I have prepared an abstract. Kindly see.
Yes.
The abstract is here. These are the offences alleged in the FIR.
Yes.
Lord, 318(4), 319(2), 336(2), 336(3), 342. The end offences are given in the side column. Kindly see.
Hmm.
Lord, there are 3 persons alleged in the FIR. One is Babita Patnaik, claims to be the landowner. She says that forging her resolution, Sneha Das sold these property to her properties to Sushant Kumar Patel. Am I clear, madam? Babita Patnaik is the landowner, a partnership farm. She alleges that forging resolution of her farm, Sneha Das.
But
has-
how, if the
I'm saying-
investigation is going on, why should at this stage I preempt
Yes,
everything?
Your Lordship's view, Lord, I respect your Lordship's view. There are 2 judgments of the Honorable Supreme Court I am citing, my Lord. Kindly consider. Lord, on plain reading of FIR, if
Can I preempt everything at this
Yes,
stage
yes, yes,
and
on a reading
form an
of FIR,
opinion?
I am conscious of my constraints, my Lord.
Yes.
On a reading of FIR, if your Lordship finds that none of these offences are alleged against me, your Lordship can quash the FIR. There are 2 judgments, kindly see, my Lord.
Yes.
Judgment, no? Yes, my Lord. This note is here.
Hmm.
My Lord, kindly see para 13 of first judgment, my Lord. para 13.
Vesa holding.
Besa holding.
Yes.
Kindly see, ma'am. It is true that a given set of facts may make out a civil wrong as also a criminal offence, and only because the civil remedy may be available to the complainant, that itself cannot be a ground to quash the criminal proceeding.
Yes.
The real test is whether the allegations in the complaint disclose a criminal offence of cheating or not. In the present case, there is nothing to show that at the very inception there was any intention on behalf of the accused persons to cheat with condition precedent and an offence 420 IPC, which was earlier there.
Yes.
In our view, complaint doesn't disclose any criminal offence at all. The criminal proceeding should not be encouraged when it is found to be mala fide, otherwise an abuse of process of court. The superior courts, while exercising its power, should also strive to serve the ends of justice. In our opinion, in view of these facts, allowing police investigation to continue amount to abuse of process of the court, and the High Court committed an error in refusing exercising power under section 482 CRPC to quash the proceeding.
Yes.
But now, your lordship, Lord, there is also one more judgment, my Lord Usha Chakravarti. Lordship must have come across these judgments.
Yes.
Page 18, man. Para 16. In the same line, Lord, these are all 323, 324.
That case is arising out of 156(3).
Yes. Complaint or FIR, my Lord, all the more same thing. Lord. There is nothing different. Complaint and FIR, all the more same thing. Lord, what is the test on reading of FIR and the offences alleged in the FIR, whether will implicate the petitioner? That is the test. If a lordship finds from the FIR that these offences, which I have given, abstract of which I have given, there is any allegation involving the petitioner in these offences, but then I have no case. I'll have to go back to the investigation. I'll have to go back to the
You tell all these things to the investigating officer.
I can appreciate I can appreciate your
thereafter you will have right cause of action.
Lord, let me tell,
why should I at this stage
because
preempt the investigation?
Your lordship is
and dwell upon to all these issues.
Lord, your lordship is not preempting, not at all preempting. The FIR is before my lords.
Yes.
From the FIR, your lordship will find the whole gamut of allegation rounds around 3 persons. I am no way involved there in the FIR. Kindly see, involving these offences alleged. If there is a whisper that I am involved in the cheating,
yes,
I am involved in the execution of document.
You are the developer.
No, I am not the developer. But the informant's land is the place beyond my development agreement, beyond my developed area. I am a separately together different developer. I am having my own land. There is no dispute about that.
Yes.
But these
come to the FIR then.
Right.
Let us see.
Correct. Kindly see.
Just in the first blast, let us see if
1 minute. Before that, can I just take 1 minute time of my lords? 1 minute time. What is the issue here? Issue here is I am a developer of particular A land. A land is mine. There is no dispute about that. Informant's land is behind my land. I have not taken any sell deed from that land. No.
You are eyeing over that land.
I know
difficulty.
If that material is there, that I have taken.
You are a developer. You are eyeing over the land. Therefore, he has filed it.
He is.
Let it be investigated. Let us understand. You may not say.
No, unless
that's the apprehension.
No, that cannot be. Not unless he says in the
reality
that I am eyeing. That's
the reality.
That's not the reality. Lordship can take an undertaking.
You might have negotiated with him. He might have refused you to give that land. Now you.
But today, before my lords may take an undertaking from me, but I will not take that land. Anyway, take an undertaking from me.
Let us come to the complaint.
Take an undertaking from me that single inch of land today and in future we will not take. We will not take.
I think you should tell that to the police. IO.
I have great respect to my lord's opinion, with my lord's experience, my lord. My lords, kindly see, it's a case.
Let us understand. Let us read the complaint.
Yes,
anything made out or not.
Right, my lord. Kindly see, my lord. I, Babita Patnaik, is it about 50 years, wife of so-and-so, so-and-so, so-and-so.
Yes.
I, being sole proprietor of Cargo Lines, registered office number so-and-so, so-and-so. I have purchased patches of land. These are the document numbers. After purchasing above 27 plots, I am enjoying the same peacefully with knowledge of the whole world. On 11/12/23, I applied for incumbent certificate from online platform so-and-so plot, obtained the same from District Sub-Registrar Bhubaneswar, and came to know that all the above noted plots have been sold by one Sneha Das. Sneha Das is her partner.
Yes.
her partner, my lord. Documents will show that Snehasi is her partner. Snehasi Das, aged about so and so, so and so.
One Susanto.
Susanta is not connected to me. Susanta Patra is the purchaser. The resident of plot number so and so, these are the documents from which I became astonished and applied for those 4 sale deeds on so and so in online. After obtaining those 4 sale deeds, verified the same and came to know Snehasi Das has executed those 7 numbers of sale deeds in favor of Susanta Patra by executing forgery resolution. These are the allegations of forgery and cheating. Next, Milords, kindly see, Milord. It is pertinent I am the sole proprietor of cargo lines. My firm is not maintaining resolution register. No resolution is passed so and so. It is crystal clear that Snehasi Das and others, by creating such forged documents, has executed above 7 documents in favor of Sushant Kumar Patra. It is more surprised that Sub-Registrar Bhubaneswar has executed these sale deeds, which is violating norms of Registration Act, and such conduct of public servant is nothing but to abet the crime being hands in gloves with the land grabbers, such as sub-register, GST certificate, seal of my so-and-so, letter pad, etc. It is worthwhile to mention here that on proper verification and security, I became sure that my signature was forged by Snehasi, and he being conspired with Sushanta, Balaram, Pratap, Advocate Dilip Behra, head clerk, sub-register, and many others have created forged documents. Last two
last it is the right place.
last last allegation co-offense doubtful. Co-offense she suspects that I have invested
The money is invested by you.
Which money?
It's the purchasing of the land by the Susanto.
Sir, co-offense
That's let us
that is the point.
Suppose you have invested the money.
Sir, खाली कहले तो इन्वेस्टिगेट हबन
and 120B will come.
Sir, मु खाली गोटे कथा कहूची ए जो कथा कहले जे right, it is right place.
Suppose this last part of the allegation is found to be correct. Then 120B will be there or not?
But as on date 34,
it is, forget about this offense.
120B is not here.
120B will be made out.
120B is not in the affair.
May not be, I don't know.
Sir, kindly consider.
Do you?
Hala, sir,
is it necessary that 120B should be there in the FIR?
Sir, mu koi tebe gotte katha more
consider. Conspiracy is alleged against you.
Sir, mu kahuche sei kathata. Jodi conspiracy kathata kahuchanti je I have invested money, there must be some prima facie material that I have.
Let them find out.
The case diary asla dekhanu ati kichhi achi dekhantu. Sir, case diary mein dekhantu investigation.
Am I here to? I am
not asking. Let the state say that there is, this is the.
That is why I asked for status report.
Yes.
Let him file the status report.
Let him file it.
Because it's a case of 120B.
That's no, 120B is there. That is the particular.
I don't know. Then you should be happy that 120B is not there. You're out.
I am happy.
You're out.
Sir, I am happy. Kindly see the affair.
Status report.
Status report we have obtained.
See the last paragraph only allegation is there. This Sushanta has done everything. Sushanta and Snehasi have done everything. And his plot is, he is developing a piece of land adjacent to that land.
Yes.
She thinks that the entire money is given by this man.
It out allegation hai period. Mu dauchi boli 420 mu padi.
So maybe because you are a big builder, you might have.
Sir, it cannot happen.
Maybe, I don't know. Maybe, but 120B is
the instruction has we have obtained.
Show me instruction. If 120B is made out, then I can't.
Last para.
Sir, देखो
there is some other person may involve.
देखो sir. अपन जब सेटा privacy पाउचंती, then I have to go to the IO. No problem in that.
He doesn't say anything. He only says that it's still going on. Sushanta and he's not.
But I'm a company of national repute. My managing director.
File the right status report. What is the role of this?
Yes.
Man? Yes. If this is the only allegation, you have to connect.
Some other person might have.
Maybe I don't know whether he's involved or not. I'm interested.
Yes.
Some other person may be involved. I don't know.
Sure.
You get a right status report and place it on record.
Yes.
On that basis, I'll decide. If 120B is made out, then he's out.
Yes, sir.
Certainly, my lord. I respect
Yes.
mine also.
Mr. Vishal and counsel for the state submits that he has not obtained the status report as yet. Hence seeks one more adjournment. Please after a week or so. After a week.
This saptah conducted.
See the report.
Sir, right.
These witnesses are not coming, and that's what he says.
Sir, what a date
Date will be given 1 week after the.
Yes.
You give it on 5th or 6th.
Sir, KP Karchan.
5th. 5th.
Yes.
Okay.
Item 25.
May pleasure.
Yes.
My lord, in this case, my lord, the petition challenged the order dated 23/8/2024 by the annexure 4, page 41. 41. Annexure 6. Annexure 6 running page 42, my lord.
Yes.
Latter order, my lord. Regarding my rejection, the recall petition. What happened, my lord? Yes, the petition is the informant of that proceeding, which is pending before the Learned JMFC LR Bhubaneswar, my lord. The proceedings story is that, my lord.
40?
42, running page 42, my lord. 42, annexure 4. 42, latter order. In this petition, latter order on petition by prosecution. In this petition, the prosecution has sought recall of PW3, enable him to produce one check and mark the same as exhibit. Check the exhibit colony.
In this petition, prosecution has sought recall of PW3.
My lord.
Enabling him to produce one check and mark the same as exhibit.
Yes, I am the informant
No defense.
of that proceeding. My lord.
Prosecution is paid to satisfy this court. There is no ground to explain why it produce a Yes.
Entire crux of the issue, my lord, over the check, but the IO has not seized the check issued by the OP number.
Yes.
Issued by the OP number 2, my lord, who is the accused.
Yes.
The prosecution story is that, my lord, on by 20/10/2016.
What are the offenses?
Offenses are 420. Jagana wali paisa nela 20 lakhs nela. Out of 20.
Prosecution is not coming. Who are you?
My lord, I am the informant of that proceeding. No.
What about the prosecution? Are you agreed by this order?
Prosecution. No.
Siraga recall no kale infraction se jo kisi rahibani se case re. Exhibit no kale. That is the vital issue.
What is the vital issue? Prosecution is failed to.
No, check at the time of the investigation. The IO has not seized my check.
Check was not produced earlier.
Yes, my lord. Check the seized colony. There is check number 590.
The lordship can see the charge sheet.
Yes.
Charge sheet question check kotha.
Charge sheet.
Charge sheet check kotha.
Yes.
Page
20.
PW6 na?
PW3. I am the PW3.
Handed over the Canara Bank check number so and so. Dated 12 lakh टंका request him to hold the check till he return full amount in the different date. He went to bank. He never maintained even enough balance in the account. His family and friends always involved him. He is good for amount and not to proceed legally.
What do you want? Why do you want the check to be?
Because the check is the vital issue. The check issued by the Suryakanta Samendra accused in favor of me. The insufficient fund, I have filed a case against him.
Issue notice. Have you implemented the
Yes, implement କରିଛି, implement କରିଛି.
Issue notice.
Yes, my lord.
Yes. Next. Next. Yes. Yes.
Item 26.
26 is
May I
also
please,
is
madam?
there.
May I please,
Also
ma'am?
is
Compromise between parties, my lord. Notice may be issued to
compromise
the opposite partner 1, 2 and 3, my lord.
view of recent
Quashing of affair, my lord.
That's right. What is the age of the girl?
16.
Now 18, my lord. Now 18, my lord. Now became major and compromise between they will marry, my lord.
That judgment, how will you get rid of that?
Yes, my lord. Notice may be issued to the opposite 2 and 3,
Please
my lord.
notice.
Yes, my lord. Yes, my lord.
We'll
Notice
see.
ଟା ଗଲେ ସେମାନେ ଦି ଜଣଙ୍କ ଆସିବେ, my lord.
ଆସିଲେ ବି କିଛି କରିହବନି. That's the problem.
Unless.
Unless you distinguish your that judgment, you can't help it. Yes.
Item 27.
May I be Ashish? Lord, in this case, Lord, I'm praying for crossing of the fair Lords. Lord, kindly see Annexure 5, page 33. A very peculiar case, Lord.
Yes.
The allegation of the fair Lords, वो तो गाड़ी छड़े नहीं वो धमक चमक दले so is the allegation. जो गाड़ी मैंने तो यह इसको जो साथ जावे कर ले, Lord, kindly see Annexure 5, Lord.
I'm there.
Annexure 5 years, the informant made an affidavit. My lord, she calls it, I am reading out, my lords, that I and Akshay Kumar Naik is the accused, my lord.
Managing partner.
The managing partner of MS Bhubaneswari Construction.
My lord, how we have been aggrieved, the charge sheet, page 46. The investigation and supervision disclosed that it is a false case under section so and so against the accused.
My lords, what happened, my lords, perhaps my friend doesn't know what happened. But this, what is this, how English Annexure 8, my lord? My lord, both are subcontractors under the NSI. Work was stopped. Thereafter, this petition, my lord, this present petitioner is entitled to get 2 crores from our millers. Thereafter, millers, some accessories were there at Chandigarh, and his sale notice was given to the, my lord, the informant. And informant sold the property, and he is supposed to pay the amount was, then can we see the affidavit? He has shown the affidavit. The entire
The investigation, the police says case is made out again.
I'm saying, but
You want FIR to be passed.
no, that the thing is the different affair. What I am going to convince my landlords is all the false affairs, my several numbers of affairs. He has lost. One of the affair.
Which FIR you are?
I am now challenging Annexure 1. What's my what my learned friend stated? Now kindly see Annexure 8 at page lords.
Let us understand what is your case about. You want passing of Annexure 1 FIR.
1 millers.
Because in the prayer you don't write anything.
Annexure 1.
Just see the prayer.
Criminal proceeding.
Okay, Annexure 1.
Minor.
Annexure 1 you want passing. Okay.
Minor.
What happened to this?
Annexure 8 is different formulas.
1 minute.
Minor.
Investigation is over in so far as.
Annexure 8.
In the found money.
You now you are reading something else.
GR case all over, se case all over. देखो, Annexure 8 क्या? बेटा NI Act case क्या?
No. 460.
हाँ, सेटा NI.
Where is the charge sheet related to this FIR?
My charge sheet has not yet been filed, minutes. But what happened? I am going to convince millers. This case is since 2020 millers.
23.
Millers 23. Millers the Annexure 8. He has given a check millers. Millers check of rupees 1,29,1 crore.
Tell the IO, I can't investigate all these things.
No, Miller, this is not bad. What I'm telling Millers, allegation होची जो गाड़ी तो वेगा नहीं गला बोल छड़े गिरी. अच्छा से गाड़ी तो आप kindly see Annexure 5 and 4 agreement और affidavit. See हम उसने बिक्की ची. The liability जवाब है से admit करो.
Therefore, you have to go and tell this, show this document to the police. Police will verify the authenticity of this document.
And he has a verified Millers Annexure 8. Annexure 8 रे कौन है? अगर जो चेक तो देसी मना कर ला उधर केस है ला. सेटा फाइनल फॉर्म पुलिस कर ले. जो ये तो liability जवाब है चेक देंगी तो ये तो false case कर. सेटू खसिया पे पूरी एटा उठा कर. This is by approval Millers. Man kindly see Annexure 8. So the clearly है 133 number check. कुट्टी ऑफिस में करा liability payment करिए अपने देंगी. सेटा false वाली मैंने फाइनल फॉर्म करा. But agreement agreement affidavit
Why don't you appreciate one thing that I can't go into all these things when investigation is.
let a status report be
Why should I? Investigation is going on.
what
And go and
happened?
tell all these things to the police. And police will deal with all these things in accordance with the law. I will give a direction to the police. And thereafter,
Right.
even if the charge is filed, then you have a right to file. I'll give that liberty also. That liberty also. Both the liberty I'll give. Ah. Right down. I know, I understand it.
4 and 5 minors.
Absolutely. Write down. Petitioner has filed the present petition seeking quashing of the FIR number, FIR Dharamsala, PS case number 323 of 2023 on various grounds. He has filed several documents before this court in this petition to impress upon the court that the case is absolutely a false case. False case. I'm afraid at this stage, this court can go into the authenticity, verify the authenticity of those documents. Therefore, since investigation is going on, also. Hence, this court is not intending to entertain this petition of justice. Rather, grant liberty to the petitioner to place all these documents before the IO, who shall deal with these documents in accordance with law while filing the report under section 173 CRPC. CRPC. Petitioner is also granted liberty to agitate the issue at the appropriate stage if cause of action still survives. Yes. He may file a closure report. If he doesn't file, then again you can come.
It was assured by the police, but because of some problem.
Now the direction has gone. Yes.
Item 28.
28. Yes, madam.
28 praying for an adjournment, my lord.
Why, madam?
My lord, there is some instructions are needed, so 2 weeks after.
What are you asking by the
My lord, passing of the cognizance, my lord.
cognizant? You not filed the charge sheet also. Where is the charge sheet?
Only the cognizance and the
Casually you have filed for the casually you have filed this petition. Put it in February.
No, I beg your pardon for the same. This mistake is not going to repeat.
There is nothing in this matter. Only you have filed for the sake of it. It's all right. We'll see. Yes.
Item 29.
29.
Yes, sir.
It's a wholly misconceived prosecution by the OPID under the impression, my lords, we are dealers in cryptocurrency. Admittedly, my lords. They have an impression that dealing in cryptocurrency is akin to chit fund.
Yes.
Now, my lords, if your lordship says, my lords, cryptocurrency has been held to be legal by the apex court. I'll give your lordship the judgment. This has been followed by this honorable court, even in the bail application of the petitioner, as well as in another bail application which I was arguing, which virtually reads like a 482 order, man.
Yes.
When the objective is legal, then how can illegality be attributed to the person who's dealing in something which is legal? For example, my lords, there are dalals on Dalal Street. They are dealing in Adani stocks. The stocks were going sky high. No one was complaining. As soon as there is an FBI investigation, the stocks have crashed. Can the dalals be said to be doing something illegal, my lords? That is the entire question before your lordship.
Yes.
Now, your lordships will see, this is the leading judgment which has been followed.
Yes.
It are dirty term.
What are the offenses? 424.
Same, my lords, 420, like
6 OPID.
6 OPID Act. And this honorable court, following this judgment, has clearly made out that 6 OPI. I'll give that judgment also. Your lordships may kindly turn to page 173. 173 of the judgment. Seven, 8 pages from the last.
Yes.
Paragraph 6.1 166.
166.
Yes, well,
Yes.
though at the time when the impugned circular, this was a circular floated by RBI saying that the banks could not convert cryptocurrency into normal currency. This circular was struck down by the Supreme Court.
Yes.
Though at the time when the impugned circular was issued, RBI has not obviously addressed many of the issues flagged by the writ petitioners. RBI did in fact consider the issue raised by the petitioners pursuant to the order passed by the court on 21/8/2019, has also analyzed in, this is not, next paragraph, 6.167. But at the same time, we cannot lose sight of three important aspects. Namely, one, that the RBI has not so far found in the past 5 years or more the activities of VC exchanges, that is cryptocurrency, virtual currency, to have actually impacted adversely the way the entities regulated by RBI function, that the consistent stand taken by RBI up to and including in the reply dated 4/9/2019 is that RBI has not prohibited virtual currency in this country, and that even the interministerial committee constituted on 2/11/2017, which initially recommended a specific legal framework, including the introduction of a new law, namely Crypto Token Regulation Bill 2018, was of the opinion that a ban might be an extreme tool and that the same objectives can be achieved through regulatory measures.
So it cannot be banned. That's
it cannot be banned. Thereafter, at paragraph, your lordships must kindly see page 174, 6.178.
178. Yes.
Last paragraph,
Yes.
6.168, 174.
Yes.
The Crypto Token Regulation Bill 2018, initially recommended by the Interministerial Committee, contained a proposal to prohibit persons dealing with activities related to crypto tokens from falsely posing these products as not being securities or investment schemes, or offering investment schemes due to gaps in the existing regulatory framework, and two, to regulate virtual currency exchanges and brokers where sale and purchase may be permitted. Then your lordship may come to paragraph 6.170. But within a year, there was a volte-face, and the final report of the very same interministerial committee, submitted in February 2020, recommended the resolution of the been an official digital currency, for the creation and circulation of which RBI central government would have had a monopoly. But that situation has not arisen. The position as on date is that VCs are not banned.
Right.
But the trading in VCs and the functioning of VC exchanges are sent to comatose by the impugned circular by disconnecting the lifeline, namely the interface with the regular banking sector. What is worse is that this has been done despite RBI not finding anything wrong about the way in which these exchanges function, and despite the fact that VCs are not banned. And thereafter,
what do you say? What do you say about this?
That decision I got no application because that the guideline was struck down on the ground that there was no regulation by the government or trading register.
Yes,
And so cryptocurrency is illegal. But the allegation here is different, that in the name of cryptocurrency, they were collecting the deposits in a Ponzi scheme by engaging different persons and a pyramid structure.
Is it your case that they are not at all dealing with cryptocurrency?
No, so that is not a official production. It kind of come to page 19 of that. That is allegations.
No, come to the charge sheet.
Yes.
Have you filed reply? Hmm?
First time it has come. And that
So you
apart, my
filed
lords,
reply, it should be 40.
and that apart, my lords, I have never taken money from the public.
Right, so far as you are dealing with cryptocurrency, no problem. Once you collect money in order to invest in cryptocurrency and that collection money itself is the crime, then you are out.
Then I'm out of this argument that I'm proposing before your lordship.
Charge sheet 16.2, yes, during the investigation. Yes, sir.
Yes, file is a web platform which was launched with its own cryptocurrency, namely yes.
Yes, okay.
The fact that the website speaks about making yes token to replace the traditional payment system existing in the country to promote green energy seems to be highly illegal and suspicious. In order to extend the membership and Ayan Commission accused Sandeep Chaudhary, petitioner, Manoj Kumar Patnaik, Basant Pradhan convinced the investors, victims through different WhatsApp groups and organized several public meetings in Odisha will join under the network by sending them referral links. It is not that the trading in the share market is engaging as the broker.
If it is a case that they collect money, don't invest in the cryptocurrency, they do something else.
But my lords, may I just clarify, my lords? I can't do it. My lords, we open up an account in the platform. We ask them to open an account in the platform. The money is forwarded to the platform. The cryptocurrency cannot be bought by cash or anything, my lords. It goes to the virtual platform. Platform they invest. Then thereafter the investment is there. We only ask them to invest in ES currency. That is exactly what this honorable court has also held, that no offense under OPIT is made out. My lords, I will give your lordships.
Then file a response to it. Because the problem is these are so technical. Any time what happens, neither the investigating officer knows it, nor the lawyers appearing from either side knows it. The court is also handicapped on this. And these people are so smart, they take advantage of everything. That's the reality.
Your lordships will.
So it is so they are so. And see, the police, those who are not trained in this subject, it's very difficult for them to understand also what really is happening.
What really is happening, my lords? They are under an assumption that I am asking them to trade in cryptocurrency. So this is like a chit fund scheme.
There must be something in between.
If they can show a single rupee which has flowed to my account, my lords, I have no case. They give it.
Just tell me, you ask your investigator, and he will come and brief you and prepare a proper chart, how things are moving. In what way they collect the money, in what way they invest that. Collecting money and investing in crypto only, then they don't have a case, you don't have a case at all. Because court says that it is a regulatory method.
Was going outside India.
Maybe through cryptocurrency it goes, then you don't have a case.
16.14. Is the investigation the involvement of from the outside of the country?
No, see, the one which you read it out, you say that we suspect. After charge sheet, if you in the charge sheet also you say suspect, on the basis of suspect, why should at the stage of investigation I can understand. After investigation, you come out with the clear case. This is the case. But in the charge sheet, you say that we doubt it. And because of your doubt, they will face the trial. That's what you are read it out. See 14.
16.8. Investigation further revealed that initially Sandeep Chaudhary of DSOL and his associates promised to pay high returns to the investors with the intention to create more investors in downline.
Have you collected those emails?
Yes,
you filed those emails. What are the language used by them?
Yes.
They've allured the people to collect the money?
In WhatsApp group, they were.
Have you collected those evidences?
That screenshot.
You get
and my lord, the payment is person to platform. It is not.
But in the same time, if you have allured them that we will.
My lords,
make it double and all and.
my lords, I can allure a person, for example, Adani stocks. I can allure you, the general public, you invest in this company, it is growing fast. If you invest 100 rupees today, it will become 1000 rupees tomorrow. So, my lords, that no illegality can be attributed to me because the ultimate goal is legal. Here also, if cryptocurrency is legal, if I allure them, if
I
let us
understand.
say, for the sake of argument, 100 rupees you invest, you will get 1000 rupees return from this cryptocurrency, and they have earned huge profits. Suddenly it has crashed. Again, it may pick up. That is exactly why this honorable court has held that no offense under section 6 is made out.
Yes, if that alluring, suppose an agent, LIC agent or anybody comes, it's kind of alluring only. Alluring only to give good return.
Share credit or in cryptocurrency. They cannot allure me.
Acha? Dalal Street, that means Dalal Street is not there.
Choice of
Bombay.
what they were doing.
No, the investment bankers. What is the role of investment bankers? They will come and tell you this much amount you have, you invest in this share, you will get. If the share is crushed, can you say that it is allurement? I am just giving an example. Anybody can come and tell you that you invest in this shareholding and you get good money. And it was really going up. But all of a sudden it crashed. Then can you say that it is a crime?
That they were investigating the depositors to downline members and earn commissions. That is the allegation.
Even then it is not. Even then the crime. See, in that MWay product you have seen, MWay product scheme. In the MWay product scheme, what they say, you bring 3 members, you will get this much. You get 5 members, you get this much.
You get a bonus.
And bonus.
That concept is not either in share credit or in cryptocurrency credit.
The problem is,
and they were getting the order. Here they have taken out their entire money. Not returned back.
who has taken them?
Okay, let us go deep into it. Let us understand exactly. See the judgment, size of the judgment. Gone through. And this will be useful for you in other matters also.
And I've argued everything, and still then this honorable court has held section 6 is not at all made up. So, my lords, in a bail application, of course, now I'm in a 480.
You take the judgment. Now it's so technical, it's very difficult to understand unless you.
If you filed an IA, my lords, stay up for the process.
Let them move application for trial court for adjournment. If at all starts, you will move application for. It's all right. Let him move an application and we'll examine it. If it is.
Revision was filed, no, revision was passed. Revision was.
I am not passing any interim order. I am only giving liberty for asking an adjournment. Going to the fact that matter.
Revision was filed, file a 482. We have taken leave of this honorable court to file a 482 because it was not maintainable.
Okay, so that is no problem. You file a written reply. Okay.
That observation.
Yes,
okay.
okay.
was in bail on the 28/9/2024 by the 28/9/2024 by the annexure 2, my lord.
Yes.
Annexure 2 page 12.
NBW 9/10/2024, 500. Yes.
But whatever was in the interim bail. Interim bail.
It's all right. Interim bail. Yes.
Item 31.
Interim bail. Yes. 31.
Item 31.
Let us say Belgium matter. NBW was issued on 29th of October 2024, and earlier he was bail on dated 6th of October 23.
6th of October.
Annexure 2, page number 16.
500. Yes. Allowed.
Item 32.
May I please.
Here, my lord, I have prayed for passing of FIR under annexure 1, my lord. Before I submit, my lord, I want to state that earlier, my lord, I have approached this honorable court. My anticipatory bail was rejected. Thereafter, I filed the present petition. So here, if your lordship will see, my lord, the entire case is
Passing FIR.
passing of FIR. My lord. Entire case arises out of the political dispute. Your lordship may see the FIR at annexure 1.
Yes.
Page number 11, my lord, was instituted.
You appear, I'll protect till December 25th.
Lords.
Okay. Hello. Petitioner is seeking passing of FIR number so and so. for alleged commission of offense intersections also. He approves this court by filing ABPL number 11692 of 2024, which has been turned down by the coordinated bench of this court by order dated 28/10/2024. Thereafter, the petitioner has filed the present petition seeking question of the entire criminal prosecution against him. The counsel for the petitioner submits that he would reserve his right to reserve his right to investigation is still going on. Since submits that since investigation is still going on, he would reserve his right to approach this court after the charge sheet is filed. However, the petitioner seeks liberty of the court to appear before the appear or surrender before the court on or before 25th of December and move appropriate application for bail, taking all the grounds which has been raised in this petition and this petition, subject to petitioner appearing before 25th of December. The anticipatory bail application is rejected, asking you to appear, na?
Millards, 28/10/2024.
Subject to the petitioner is directed to appear before the court on or before 25th of December and avail the benefit of the order dated 28/10/2024, whereby the coordinated bench has directed the trial court to consider the bail application on the same day, on the basis of the material on record and by maintaining the principle of fairness. With this observation, the petition is disputed. Yes.
Item 32, 33.
Yes.
In this case, matter of criminal proceeding was initiated on the basis of the final report of the state level scrutiny committee regarding caste, your lordship. And as 1, page 10, your lordship. See.
Yes.
Your lordship, the relevant page is.
Yes.
Your lordship, page 13, your lordship. Page 13, where the final order is the FIR. Final order of the state level scrutiny committee is the FIR. Is this impugned order was challenged in the writ petition? Writ petition, you must stay the further proceeding. And in the meanwhile, I also.
In the writ petition, this final report was challenged.
Was challenged.
Okay.
That was stayed. And the writ is now, of course, disclosed of quashing the impugned order.
The scrutiny committee report goes.
Your lordship.
Tell me what do you want to tell? See, if you come to page 12, the entire basis of the FIR is the state level scrutiny committee report. Okay?
Yes.
And what he says that the state level scrutiny committee report has now been set aside by the division bench.
Yes,
in the writ petitions.
Single.
And the basis of the FIR goes. That's what he says.
And SR 3, your lordship.
Yes.
Writ petition, your lordship, order.
Yes.
And SR 3.
What is your answer to that?
Your lordship, of course, he cannot get the order also because the order was passed on 27.
27 of this month.
That's not even uploaded. Not even uploaded.
Get that order, I'll just put it. Get that. Simply urgent. Just check it up.
It is not even.
Okay. Simply urgent to next week. Next week. Next week.
Item number 34.
And give a date that you can come on 12th. 12th December. 12th December. Okay. 34?
Yes, sir. This is the case, my lord. A proceeding was initiated under section 125 SFC.
Yes.
Right, and 1, page 8, your lordship.
Yes.
In this case, my lord,
the opinion for two minor, who is the
Why?
complainant in the
Yes.
125 proceeding, has earlier filed a FIR against the petitioner alleging 376 and 319, and that FIR I challenge before your lordship. The lordship has dropped the proceeding 371,
Yes.
376, and 319 is still continuing. Trial is on. In the meanwhile, the complaint pay this 125 proceeding.
Then the maintenance, you have to pay the maintenance.
Well, rape case, your lordship, I have to maintain. He has filed a rape case against me, 376, alleging that I your lordship, stay, your lordship, because your proceeding.
Maintenance, why should I stay you?
Well, because-
It is a matter of how much the court is asked you to pay.
What
What is the maintenance amount?
Whether once
What is the maintenance amount I'm asking?
month's amount is claimed, my lord, 40,000 something.
No, what's no
30,000.
something exactly tell me.
He is also in your lordship, see the.
You tell me the amount.
Lordship, now the question is whether it is maintained or not. Once
Tell me the amount. What is the
30,000, lordship.
30,000.
30,000. Now the court has also asked what is the marriage.
I'll give a short date.
Short date, your lordship.
I'll give a short date.
Your lordship.
Let it be 12th only,
Yes,
because you are coming in that
Well,
matter.
well,
12th. Take out the notice with
Yes,
you. Okay.
Item 35.
12th, huh? 12th. Issue notice to opposite party number 2. The requisite to be filed within 2 days.
Monday.
Okay. File tomorrow. Why?
Monday.
Yes. Yes.
Item 35.
35. Yes, sir.
Item 35, Milord, I may be permitted to face this matter on behalf of Manoj Jalpal.
Yes. Yes, sir.
In this case, I am seeking a direction to the lower court to consider my bail application in observation made in the ABLPL number 1533 of 16.
1533.
Annexure 2, that is Annexure 2. Page, Miller, running page 44.
Yes.
May I place that?
44.
Yes, Miller.
Yes.
The application for modification is not well conceived in this sense. The petition appellant that the learned.
Where are you reading, sir?
Last 44 second.
However, keeping in view. Keeping in view.
No, that's that. Sessions Judge cum Special Judge Koraput, while disposing bail application shall consider the statement of the principal accused person. It is well settled principle of law that the statement of a co-accused is not admissible to implicate on if it is not made in the immediate presence of the magistrate. This observation should be made. The fact of this case, I am entangled in this case on 20B2C, basing of the confessional statement of one co-accused. Of the magistrate is very much present in that scene. But he has not recorded.
I am not able to follow. These are the observations made in the bail application.
Bail application.
Whose bail application?
Another bail application.
Huh?
Another bail application, not this person.
Whose bail application is this?
This is a person, Sankar Bahadur.
In this case or some other case?
Some other case. That observation should be that Tufan Singh case is there.
That's a different thing. In a bail application moved in some other case,
yes.
Some observation is made. You want that observation should be applied to you in this case. What is it? What kind of prayer is this? Tufan Singh is there.
Yes.
There is a judgment in RAM that has to be
Yes.
followed.
Yes.
But this is the observation. I don't know what is the fact of that case.
Yes.
And what context this observation was made. 3-line judgment.
But the lower court is not considering my application basing of Tufan Singh case.
I'll just see. It is expected that right up.
Yes.
No. Yes. Okay. Right up. A petitioner is in this petition is exploring the following prayer. Please, the learned counsel or the petitioner submits that he apprehends that the bail application to the you are in custody.
Yes.
The petitioner is in custody. The petitioner is in custody. He has moved an application for grant of bail he apprehends that, no, he submits that the observation made by this court while disposing of the bail application of one of the accused. What is the name? One of the accused in which FIR? One of the accused in TR case number 10 of 2016 shall be taken into consideration while his bail application is to be considered. Because the observation made by this court while disposing of the BLAPL number 15111 of 2016 is on the basis of the judgment of the Honorable Supreme Court in Tufan Singh and so on. It is the petition is disposed of with a direction to the trial court to dispose of the bail application of the petitioner, relying upon the judgment of Honorable Supreme Court in Tufan Singh with this objection. Yes.
Item 36.
Please, Your Lordship. My lord, in this case, Your Lordship, the police filed charge sheet. The present petitioner is in behind bar, charge frame, and after examination of 25 number of charge sheet witnesses, one exhibit 15-1 is there, my lord. That exhibited. The exhibit 15-1 is the school admission register, my lord.
Yes.
That came to the light of the learned court below. I am reading the page number 48, my lord. PW 23 statement.
48.
My lord.
Yes. By the way, what are you asking here?
My lord, here I am filing a petition before the learned court below, saying the after exhibit of 15-1 exhibited, it came to know that the victim is more than 22 years old at the time of incident. So alteration of charge is there. Charged 6 POCSO is not attracted in my.
Where is your application?
Application before the learned court below that I have not appended, but everything is my.
Show me that application unless you.
My lord.
62.
My submission is there, my lord.
Your submission is later on. Not you file the relevant application.
My lord, my submission is there. The learned court below recorded my submission.
She wants to show something. Yes, madam.
Learned counsel for the accused petitioner submitted that. In the meantime, giving the
Paragraph 2 of 4.
Page number 62, annexure 3.
Okay, 62.
What the challenge?
Learned counsel for the petitioners submitted that.
Was marked with 15-1. It reveals the date of birth of the victim.
Date of the victim girl to be 9/6/1998.
So in the earliest date of. I've seen it. I've seen it. You have not filed anything. Have you seen the judgment of the Supreme Court? How will you distinguish that judgment? Except FIR, you have not filed anything. No affidavit, no nothing.
Lords, on the next date.
In the FIR also didn't want to go with it.
Your Lordship, may kindly fix a date, my lords, for the appearance of the parties on that date.
Not appearance, sir. You have to file a proper petition. What kind of petition is this? One paragraph petition without annexure, without anything.
Annexure is there, my lords. Annexure 1. FIR, my lords, I have annexed, my lords. I have annexed the FIR.
No, nothing.
Investigation is over. Nothing is coming out. What is this?
And my lords, it is investigation in progress, my lords. My lords, fix a date, my lords. On that date, we will apprise the honorable court with all the documents, my lords.
But and sir, also, you have not filed anything in this petition.
My lords, I have annexed the FIR, my lords. It is in the stage of investigation, my lords. FIR of my lords for 12 April 2024, my lords. My lords, 21/8/2024, my lords. FIR of August 2024. So for that reason, we have limited documents. Whatever else, my lords, we will apprise the honorable court, my lords. On the next date, my lords, when the parties will appear and file the joint affidavit, my lords.
It's February. Yes.
January, my lord, short date, my lords, with the board parties, my lord.
Not short date. I am not inclined to entertain this petition. There is bereft of any particulars. One line only it is written that it is, we have settled the dispute.
My lord, my Bakalna may be accepted.
On advance notice, so and so entered appearance on behalf of Populous Party number 2, file Sibo Sankar which is taken on record, leave the matter after. Yes.
Item 38.
Set aside the order dated
Yes, madam.
Fresh admission of two appellants are there.
Two appellants.
Yes, sir.
Sentence?
Husband and wife, 3 years.
3 years. Same order, huh? Okay, okay, allowed. Your prayer is allowed. Not the appeal. You, temporary relief. Okay.
Two appellants are there.
Bail granted and realization of fine is
paid.
also stayed and TRC called for.
And yeah, free copy.
Free copy and Mr. Sanjay Das. Yes. That's very important. I am not saying he, Mr. Das is saying. I am not saying anything.
He will not have to. Your lordship have remembered.
No, but these people are saying. Yes.
Item 39.
Yes.
This is the application on the.
Yes. 39.
Yes, sir.
Yes, sir.
The application challenging the order dated.
Vigilance.
Yes.
Yes, see. Have you given the copy to them?
Yes.
Yes. Yes.
Application challenging the order dated 11/7/2024.
Yes. What is this order? Let's see.
Rejecting discharge petition.
Rejecting?
Discharge petition.
Discharge. Yes.
May not kindly have a glance to page number 28, the FIR.
28.
Yes, ma'am.
Come to the charge sheet straight away. In the FIR, you may not get anything. Ravindranath Das.
Last three pages of lordship contains the charge sheet to us.
Yes. Yes.
Last three pages starts with brief factor case law. Page 1
Yes.
This particular allegation of misappropriation of government funds in educational plantation work. Sally Java under a particular scheme that is compensatory station monitoring of the agency. Next page. The next page is third paragraph. David technical inspection revealed that only 2,092 plants have been planted. Then the fourth paragraph, that's first petition completion is the scenes records and documents reveals that the vouchers have been prepared by the forester say Ravindranath Das and officials. Govindo Chandra Jena, and now the present petitioner is the Ravinder Chandra Das.
Yes. Accordingly, the forester Ravinder Chandra Das has made the payment and.
I'll have a glance.
Officer, so the amount of misappropriation liable to the part of the person, part of the officer, and rotate below. The last one, say Ravindranath Das currently is liable.
Yes.
So direct operation is there and speaks about this.
May not kindly have a glance to paragraph 2 of that.
Paragraph 2.
Yes, ma'am. Out of the funds allotted for the plantation work, the range officers have made total expenditure of rupees 3,44,617 through different bills and voucher which has been seized. Sri Govinda Chandra Jena, range officer expert, made expenditure of 2,39,425. Sri Biranchi Narayanath, range officer, made expenditure of 37,706. And Sri Dibakar Panda, range officer, made expenditure of 67,485 rupees and 60 paisa during their incumbency in Tumakare. My lord, the petitioner is nowhere connected in this. The voucher seized by the.
But you have relieved the you have disbursed the amount. That's the allegation.
My lord, I don't have
on the basis of the forged.
My lord, for that reason, I kindly have a glance to the FIR.
Yes. FIR, after FIR, the investigation has taken place and these are the facts.
I don't have any power to disburse the cash because
it's not a case for discharge, sir.
My lord, the voucher seized by the vigilance department
from Govinda Chandra Jana range officers and Dibakar Panda and
That is
Viren
what
Saranda.
these vouchers were prepared and the money disbursed by you.
I don't have any power to prepare the voucher.
It's not
because the total in charge of this
See, 120B is there. Why don't how can I
my lord, the in charge of this scheme is Mrs. Ansu Praganath, who is the SCF, and he has to she had to inspect the work and countersign the vouchers, and she had not checked
all these things you have to put to the witness during the trial.
No, my lord,
I can't decipher everything at this stage.
No, my lord.
16/6/2009 till 31 August 2011 till your retirement.
My lord, I am the forester of Doburi section.
Anyway, you don't have a case, right?
Well, I have a case because Mrs. Ansu Praganath also could not charge sheeted because she had countersigned every vouchers, but she has no direct. The prosecution says that she had no direct involvement. But I just made the payment, so I have the involvement.
What to do?
My lord, this is if according to their statement, on the basis that Ansu Praganath is not charged, that she had not.
If somebody is not charged, doesn't mean that you are.
The ground taken by the prosecution to not charge Ansu Praganath. On the same ground, I don't have any involvement in this case. Because she had countersigned every voucher.
But he must be smarter than you. He has done right thing in right time.
She countersigned every voucher, but she had not charged it. But I just made the payment, so I haven't charged it.
I can't go into all this thing at this stage.
My lord, this is in the charge sheet.
11/7/2024, whereby his application for seeking discharge has been rejected. After investigation, charge sheet has been filed in the present case on 22/6/2019 for alleged commission of offences punishable under section 468, 471, 120, capital B, read with section 13(2) and 13(1) C and D of PCL 1998. I have perused the charge sheet and the allegations level against the petitioner. I am not. I am in full agreement with the impugn order as the prima facie case is made out against the petitioner. The trial court has rightly rejected the petitioner for this one discharge. Hence, no interference is called for. At the same time, liberty is given to the petitioner to raise all the points before the trial court at the appropriate stage. With this observation, the petitioner will dispose of. Yes.
Item 40.
On behalf of the petitioner, my lord. Am I audible, my lord?
Yes, sir.
My lord, in this matter, my lord, we have come against the.
On behalf of Mr. Naik, praying for an adjournment.
You are for?
Mr. Naik, CBI.
He is for the response and the opposite party.
Notice has been issued? No.
No, my lord.
Let us see whether it deserves notice or not. Yes.
My lord, in this particular matter, my lord, actually, the CBI organization has entangled many, including the petitioner, my lord. And he was granted bail by the Honorable Supreme Court, my lord. My lord, the petitioner is a consultant, my lord, is a financial consultant and gives consultancy to various firms. So this company also took consultancy from this petitioner. And in lieu of that, fees were paid to the petitioner, which is now stated as a proceed of crime because this particular matter, my lord, has come up for investigation under the scanner of Honorable Supreme Court in that Subroto Chattoraj's case. My lord knows that. Now, my lord, on the date prior to that, I was called to CGO complex at Kolkata on various times.
Yes.
I cooperated
I went there, I met the IO, and on 26th of September, my lord, in 2022, I was, my lord, taken into custody at CGO complex. My lord, thereafter, I was in incarceration for over 1 year. When Honorable Supreme Court, I would say, my lord, subject to your lordship's correction, that came to my rescue and granted me bail. My lord, on that particular day, they came to my office and took 15 lakhs of rupees, saying that this was the proceed of 2012. My lord, I have given all the documents. I have stated presumption of innocence is in my favor. I have been granted bail by the Honorable Supreme Court. Now they have filed a charge sheet. Let them prove, my lord. It is only the opinion of the CBI, and thereafter nowhere it is written that cash amount was taken. My lord, if that be so, my lord, I have made an application under section 451 and 457 of the CRPC for the release of that particular cash amount, for giving me the custody, in which I shall be furnishing a bond, my lord, subject to your lordship's whatever desire or whatever your lordship.
What's the amount? What is the amount?
15 lakhs.
15 lakh. It is arising out of a 457 application which has been turned down. Yes.
My lord, wherein Sundar Lal Bhai, Ambal Lal Desai, Manjit Singh and other court cases goes to show the Honorable Supreme Court has laid down this principle. Unless and until they entangle me, they prove that this money belongs to something, a proceed of.
You furnish some security.
Yes, my lord. I am ready to furnish.
Property security or something. Huh? Yes. What do you say? You ask him, I'll just issue notice, I'll put it next week. If they will furnish property security, why do you need the cash? Let them use the cash somewhere for their benefit. Okay. They'll furnish some property security or 50% of bank guarantee or something of that sort. Find out the way and tell me. Okay. I'll issue notice, sir. Let us see and explore the possibility of what way it can be released. Okay. Furnish some security, I'll release it.
My lord, one more thing, my lord. My lord, what happens, my lord, as I have a little bit experience about this, I don't have much experience about the Honorable Orissa Court. My lord, the other matter was dragged for more than 1 year when the wife's ornaments were released. My lord, a short date I would be praying for.
Yes, that's what I'm saying. And after 2 weeks, just after issue notice, after 2 weeks. Huh?
They also need to change cost.
Week commencing from 16 to make it on 19th, 18th or 19th. 18, 19, no?
They also need to change cost title.
18. You change the cost title. Now there is a judgment of Supreme Court which says that you can't write Republic of India.
It has to be written CBI. Learned advocate on record, Mr. Behra is there. I can see him.
Yes. I'm just asking him to correct it.
Yes,
correct it.
Leave court here and now.
Yes.
Item 41.
You just tell Mr. Naik that this is regarding release of 15 lakh rupees and they will furnish some security like property security, whatever security. You seek instructions so that we will decide. Yes.
Item 41.
Belgium matter, my lordship.
Yes, NBW, my lord, having no, the petitioner having no nexus. Neither he has been named.
I'll cancel it. You're going into the merits straight away. Yes.
There is on 8/1/2013 and NBW was issued on 18/3/2013.
13.
Yes.
And you have shouted so much, you pay 1,000. 1,000. Yes.
I can, sir, only I can understand. Suppose if there is an affair, if my name is there in the affair. Sir,
go into all this.
Only, sir, 1 minute. Not. I have not been named in the affair, nor any of the co-accused also stated my name. Number one, only allegation against me is that the vehicle stand registered in the name.
Why are you absconding then?
Not absconding, because the matter is also there. Sir.
Pay 1,000.
Sir.
Yes. Next.
Okay, sir.
Item 42.
11/20/2024 and NBW was issued on 11/9/2024.
500. Yes.
Item 43.
Variance on 29/11/2019 and NBW was issued on 28/2/2023.
23. 500. Yes. 500 each.
Item 44.
Item 44. On the last occasion, your lordship called for the status report, my lord. Status report is at flag H.
Called for a report from the Lawrence.
And order dated 22/11/24.
Okay,
Your lordship
just
see order dated
let us see,
22/11/24.
It has come on.
And also criminal antecedent has been obtained. There is no criminal antecedent. And charge framed, but trial has not yet started, my lord.
Report hasn't come?
Report flag H.
Flag H?
Yes, my lord. It is there.
Yes.
In the month of February, charge has been framed, but till date, no trial, my lord. Already more than 1 year, 7 months in custody, my lord.
You're in custody since?
Custody since 14/4/2023.
14?
Said to produce the 14/4/2023.
Yes. What do you want?
Your lordship said to produce the judgment of that Ravi Prakash.
Ravi Prakash?
And charge sheet filed on 10/10/23. 19 charge sheeted witness, not yet started.
154 kg of ganja outside.
Outside, that is the problem.
Any family member, your lordship may say, stringent conditions.
You are?
Phase 1 year. Bhojpur, Bihar.
Yes. Where is the affidavit? Where is the affidavit? I asked you to file affidavit.
No, my lord.
No, you have to file affidavit disclosing which police station you are there in Bihar, and give the number of that police station and everything. Thereafter, I will release. Monday, Tuesday? Tuesday. You give an affidavit declaring that you are not involved in any other case. And after release of bail, you will stay where and which police station, and number of that police station.
Local security भी वो करते हैं.
And local security you want to furnish?
They have obtained instruction. Antecedent is not there.
No. You write all this thing in your affidavit.
Yes.
And say that local security, so and so will be the local security. Write down that affidavit. I'll reproduce and release. Okay.
That's it. So I have to call any of his family members for affidavit.
Okay. And then you tell me when?
Wednesday or Thursday.
Okay.
Nice. 5th.
Yeah.
Yes.
Okay. 5th. So that I can record all these things by using Ravi Prakash.
Yes.
Item 46.
Item 45.
Acha, 45 is infractious.
Instructor नहीं कोई गलत है class.
Infractious. It is disposed of. Yes.
46, my lord, I prefer after launch.
Okay. I'll come after lunch then. In any case. I'll come.
Here is I'm providing the order only.
Which one?
Item 18. Here is the connected matter is serial.
I'll take it up. I'll come and take it up. Wait. Are you in hurry? You are going somewhere?
No, my lord. It's only I'm praying that it may be connected with that CRLMC.
Show me. For small matter, why should you?
That CRLMC 918/2019.
Yes.
18.
You want stay order also?
Yes, my lord. That
Let
is
me
the
see.
order.
Wait. I'll take it up. You want some interim order? Or simply take, I'll take it.
It may be only connected with that matter.
Okay, tag with this matter.
This matter.
Please tell along with this.
Yes.
Okay.
Obliged.
Enter proceeding cognizance order as well as enter proceeding.
Where is the charge sheet?
किसी दिन है खाली accept करते हैं.
What to do? There is nothing in this matter. None appears for the petitioner even in the second call. The petitioner is seeking quashing of the cognizance order dated 3/11/2023 passed by the
PO Special Court.
PO Special Court under SC/ST POA, Champua. Yes, Champua, in connection with special case number 33 of 2023, whereby cognizance of offences punishable under section so and so, page 9 has been taken. The petition, copy of the charge sheet has not been filed with the petition. Even otherwise, there is nothing on merit. I find no infirmity to the MP in order. Hence, the petition is dismissed for dismissed. Yes.
Item 4. One CC case arrange handwriting expert prayer for NI case.
NI
at the time of argument, my lord. At the time of argument, lordship space 12 lordship mechanic.
12, yes.
The last paragraph. Handwriting. 1, 2, 3. Upon the elected, where the lord and advocate for defense during time of argument by filing a petition has read before the court to send the alleged check to the handwriting expert.
The petitioner, none appears for the petitioner even in the second court. The petitioner is agreed by the order dated 25/1/2024, whereby his application under section 243 bracket 2 of CRPC for sending the LA's subject check for testifying the signature to the handwriting expert has been turned down. It appears that the petitioner, being the accused in a case under section 138 NI Act, has moved the application for sending the subject check to the handwriting expert to obtain the genuineness of a signature. The application was moved after the entire evidence was recorded and at the fake end of the trial. The complaint case has been pending since complaint case ICC number 203 of 2019 has been pending since 2019. Since the offense related to a special statute wherein stipulated time frame is provided for conclusion of the trial. The trial court has rightly rejected the application, finding the same to be frivolous and a tactic employed by the petitioner to delay the proceeding. Hence, no interference is called for. Accordingly, the petition is dismissed. Yes. Yes.
Item 10.
May I please? My cognizance is under challenge, my lord. Order dated 24/7/24. And NBW has been issued. Lordship, permit, I will raise the point before the trial court.
Where is NBW?
NBW, my lord, page 14, my lord.
24/7/24.
24/7.
What are you challenging, by the way?
Cognizance is under challenge.
The same order, cognizance. Petitioner is agreed by the order dated 24/7/2024, whereby the cognizance of offences punishable under section 341/294/323/354 capital B /34 IPC, read with section 31RS page 14 so and so of HCST Act has been taken against him. Apart from that, the court has also issued NBW against the petitioners. Letter counsel for the petitioner at the outset submits that insofar as the challenge to the cognizance order is concerned, he reserves his right to raise all the points before the trial court at the appropriate stage by moving appropriate application. However, he prays for cancellation of NBW NBW and submit that his client would appear before the court on or before the 30th of December, 30th December 2024, and resort to the remedy available to him under law. There is no threat of arrest and all.
NBW has already been issued.
Okay,
Which
execution
NBW,
of
yes.
execution of NBW issued by the impugn order dated 24/7/2024. Stayed
Earlier that has been issued 12/7/24.
Stayed till 30th of December. In the meantime, petitioner may appear before the court and resort to the remedy available to him. With this observation, petition is approved. Yes.
Order dated 24/7/24 and 12/7/24. 12/7/24.
12/7 ही कर दो. NBW so and so. दूसरा करके लिख दो. ठीक. Okay.
Obligation.
Item 46.
Yes. Yes,
Thank
sir.
you, Your Lordship.
Yes, sir.
Now all the defects have been removed. Here application for review, but on many counts. First of all, the writ petition was dismissed for default. I was the OP2 in the writ petition. It was restored without notice. After restoration, it was adjudicated also, despite the fact that my predecessor was dead by then. OP2 was dead. We are the heirs of OP2 who are the review petitioners.
Yes.
Now, Your Lordship, I have annexed the death certificate at page 12.
This review petition is pending since 2017.
But now the notice was issued, we have come up and we are moving it. My lord, what has happened, Your Lordship will consider kindly.
What is the principal order?
Principal order, my lord, now could not have been passed because the consolidation operation has been recalled and fresh notification has been issued. Now, on the basis of the earlier consolidation order, a remand has been made, which cannot be made. Had it been pointed out by the heirs, had they been substituted, they could have pointed out that to the Honorable Court. That could not be done because the heirs never came and the order has been passed against a dead person.
You have a fresh cause of action. You can very well assail that now.
No, my lord, my humble submission is it cannot be because that will create that is a fresh consolidation operation. Now the earlier order, which no more remains in vogue because of the fresh consolidation operation coming into force, has been directed to be adjudicated. And that has been a remand affecting my right without hearing me, my lord.
Show me that order.
Now that Your Lordship will see.
Yes.
That order is, my lord, filed. Your Lordship will kindly see the order that was passed by the court below settling the land in our favor has been set aside at page 7.
Page 7.
Yes. The paragraph 7. So if it is to be set aside, I have
para 7.
My lord.
Let me get through that judgment first.
My lord.
You are agreed by which judge? Para 7.
I have agreed by this judgment. Para 7 is the operating portion.
Page
7, internal page 7 of the order. It is separately file hela defect remove kariya pai.
Where is that order? I'm not. Purnachandra Dhali na? Dalai. Purnachandra Dalai. Review?
Review is by the ARC, Your Lordship.
You are referring to the writ petition page nation. You are referring to which paper? Writ petition?
Writ petition
or
order.
review petition?
Writ petition order, which is sought to be reviewed in this review.
Where is that? That order only I want. Where is that?
That has been filed, Your Lordship.
In the review, it's not to be seen.
Separately filed.
Separately filed, huh?
Yes, madam.
Separately filed.
Scanning the
memo. Under
H1.
a memo or what? Affidavit?
It is by way of a memo that is on 18/6/2018.
Hard copy ଅଛି କି?
Hard copy ମୋ ପାଖରେ ବି ଅଛି. Yes,
I think I got it. Got it. 1 minute. That is the judgment of
judgment dated 1/11/2016.
Yes, I got it.
Madam.
Yes. Para?
Para 7.
Para 7. Yes.
Page 7, para 7.
Yes. Yes. Under the circumstance.
Yes.
Under the circumstance.
But what has happened? The order that was passed in our favor has been set aside now completely. That's a right consolidation matter, not a settlement matter. And it's a settlement matter different. It doesn't create right extinguishes.
Yes. What do you say?
But in fact, they are statutory authorities. They are not the private party malad has to.
Now I have to issue notice.
My lordship, definitely, because I am alleging that I have not been.
Then you say that it has to be set, this order has to go. And the original order which is there in your favor.
Yes.
That has to be revived.
Because it is against a dead person, number one. Secondly, there has been a change circumstance. Had I been heard, I would have pointed out that. That didn't happen.
Yes. So issue notice to opposite party number. Oh, there are many. Also many.
I'll take
Okay,
notice
12 of them.
Ma'am, there's no option for me, ma'am.
Yes.
Ma'am, I have filed an interim application. Now he has fixed it to tomorrow. If it is done, ma'am, the purpose of filing the review will be infructuous. IA is there, Your Lordship. IA
Where is that? IA number?
432.
432.
Probably least anyway.
432.
Yes. Of 2024.
There is no.
Now, if Your Lordship pardons me, may I produce it for Your Lordship's perusal? It has been registered by this Hon'Ble Court registry. 432.
There are two IA, 4724 and 4824.
Your Lordship may call. That is for removal of defect that has been done.
Where is that IA?
I produce it for Your Lordship's perusal.
I don't know whether you filed it or not. Numbered.
It is numbered, my right? 432. It's registered.
Why this is not there?
It's already registered. That doesn't sound well.
Numbered, huh?
It is registered already.
Yes.
Last page ଟା ହଉଛି
432.
କାଲି କି ଡେଟ୍ ଦେଇଛନ୍ତି ତେଣୁ ସେଟା ପ୍ରିଜୁଡିସ୍ ହେଇଯିବ ମ୍ୟାଡାମ.
Where is the prayer? Where is the prayer? What do you say? No, you are seeking stay of further proceeding.
କାରଣ ରିମାଣ୍ଡ ହେଲା ପରେ ସେଇ କେସ୍ ଟା ଅଛି ସେଇ କେସ୍ ଟାର.
Arising out of 2966.
ନା ସେଟା ରିମାଣ୍ଡ ପରେ.
For the assistant. Acha, but there is no specific number there after remand.
Same.
Which is the case number?
My case number is there. I'll just point out number.
2885.
Process number. Share number tankar.
Now it is arising out of writ petition. What is this?
Say number.
Show me that proceeding.
କେମିତି ସେଇଟା ପ୍ରୋସିଡିଂ କି ନୋଟିସ୍ ସେ କଣ କରୁଛନ୍ତି ନା ଯେତେବେଳେ ରିମାଣ୍ଡ ରେ ଯିବ ରିଭିଜନ କୋର୍ଟରୁ
arising out of
ନାଇଁ ତାର ନାଁ ଦେବେ ରିମାଣ୍ଡ ରିଭିଜନ କେସ୍ ନମ୍ବର
ନାଇଁ ରିମାଣ୍ଡ ରିଭିଜନ କେସ୍ ନମ୍ବର
ଡବ୍ଲ୍ୟୁପିସି ନମ୍ବର ଦେଲେ ଡବ୍ଲ୍ୟୁପିସି ପ୍ରୋସେସ ନମ୍ବର ବିକଜ ହାଇକୋର୍ଟ ରୁ ଯାଇଛି ବୋଲି ଯୋଉଠି ଯିବ
is it registered like this the process registered as 2885 arising out of writ petition
exactly ସେ ନମ୍ବର କରୁଛନ୍ତି ସେମାନେ ଯୋଉଠି ଯିବ ଯୋଉ ଫୋରମ ରୁ ସେଇ ଫୋରମ ଅନୁସାରେ ନମ୍ବରିଂ କରିବେ ସିଷ୍ଟମ ସେଇଆ.
I number 432. 432. Which notice? The further proceeding pending before the assistant settlement officer come sub collector Puri in what will I write? Register number.
ଯାହା ଲେଖା ଅଛି ସେଠି ଲେଖିଲେ ସେ ଠିକ ରହିବ କାହିଁକି ନା ତାଙ୍କର ସେମିତି ରେଜିଷ୍ଟ୍ରେସନ ୟୁର ଲର୍ଡସିପ we can't help it.
Process register number 2885 arising out of writ petition number 2966 of 2002 is state till next date of hearing. But I have a doubt whether this number there must be
ଦଉଛନ୍ତି because ସେଇଟା ତ ନୋଟିସ ଟା ଗୁନ୍ଥିଛି ମୁଁ ନୋଟିସ ଟା ସେ ଡେଟ୍ ଫିକ୍ସ ହେଇଛି 29 କେତେରେ ଥିଲା 29/11/21 ଥିଲା କାଲି କି ଡେଟ୍ ରଖିଛନ୍ତି.
But in the notice there is no number like this.
ଅଛି ନା ମିଟର ଲେଖା ହେଇଛି ମୁଁ ଆସିଷ୍ଟ କରିଦେବି ଯେତେ.
Only writ petition written. Where from you got that number?
ନାଇଁ ତା ପରକୁ ଲେଖା ହେଇଛି ପ୍ରୋସେସ.
ଆଚ୍ଛା ପ୍ରୋସେସ registration.
ଆଜ୍ଞା ସେ ସେଣ୍ଡ କରୁଛନ୍ତି.
ଆଚ୍ଛା ଟୁ
that is the ବିଚିତ୍ର they are doing it. Obliged. Okay.
Yes.
Item 47.
Husband is before your lordship challenging the interim maintenance which has been allowed about 50,000 per month. Your lordship was pleased to pass an order on 14/8/24 directing me to pay a sum of rupees 10,000 to the wife and 10,000 to both the children, and I am paying that. But the notice was issued. I think somebody has to appear.
You are the senior manager.
My lord?
Nelco.
Yes. I am getting after deduction, I am getting 88,000. And my mother is a cancer patient. Where
is the order, final order? against which you have come?
My lord, annexure 3?
3, yeah?
Yes.
What is the order? Let us see. 37.
Your lordship may kindly turn to page 22, para 7.
7, huh?
Yes.
Okay.
The fact remains undisputed between the parties that the petition number 1 is a legal married wife of the opposite party and 2 and 3 are minor son and daughter. Since after 28 then 2020, petition number 1 along with both the minor petitioner are residing separately from the opposite party in her
30,000 to the wife and 10,000 to
yes,
children.
Yes.
50,000.
50,000 will go, my lord.
What is the area?
Area, my lord, it is interim. As an interim maintenance, it has been allowed. The lordship may kindly, from the date of filing of the application 27/7/23, and your lordship was pleased to pass an order on 14/8/24.
Yes. Show me. 14?
14/8/24.
Yes. What was that order? Is an interim action subject to payment of interim maintenance of 10,000. Wife. Yes.
I am paying that and also.
Services. Check the service.
And
Service fees. Are you paying this much?
I am paying and
Awaiting service. Wait. Okay.
Your lordship,
Interim order to continue. Awaiting service. Yes.
my lord, in the month of January, your lordship may keep it to January.
January only. Yes. January.
bless.
Give it.
Oh, bless.
Second week of January. Yes.
Oh, bless.
Item 48.
In this matter, it's a 138 proceeding. I am the accused. My lord, the impugned order.
Check amount?
Check amount is, my lord, 50 lakhs.
Yes.
Your lordship issued notice on the ground because I addressed your lordship.
Yes, service position. Service position.
No, sir. Parking service.
Awaiting service.
But your lordship said I'll consider the interim application. I'll file an application for adjournment. Your lordship may permit that.
Wide order dated 25/11/2024. Notice was issued to the opposite party number 2. However, the service is still awaited. Mr. Bose, learned counsel for the petitioner submits that the matter, the proceeding before the trial court is going on. And
1CC number 100011 of 14.
hence, he submits that he would move application before the trial court for adjournment, owing to the fact that the matter is of jurisdiction before this court. He may move such application if such application is same service tension. Yes. Move application.
Lordship,
January.
January.
January. Yes.
Item 49.
May I please, Your Lord?
Yes, sir.
The petitioner is the registered owner of a vehicle. Due to mismanagement of the vehicle, he was handed over the vehicle to the opposite party number 2. And subsequently, there was a disturbance arose between the parties. Accordingly, the petitioner filed a FIR against the informant, which was registered as a PS case, and in the said case, the vehicle was seized by the police. During the course of thereafter, the petitioner, along with the opposite party number 2, filed 457 petition before the learned magistrate, which was allowed in favor of the opposite party number 2. As because he was paid some installment to the financier.
And revision court reversed it.
No, that was confirmed. In fact, some money has been given during the course of installment. The petitioner has paid some amount. There was an admitted dispute between the parties. Without considering the same, the learned lower court as well as the first appellate court has allowed the interim release of the vehicle in favor of the opposite party number 2.
Okay. Who are you?
I am the registered owner of the vehicle.
You are.
It was
mentioned. You are not the informant.
I am the informant.
Informant also.
Informant also.
Okay. I'll issue notice. How much you have paid?
Some amount I have been paid.
What? How much you must tell me?
Some installment.
Some means what? 1 rupee.
No, my lord. I am the registered owner of the vehicle.
That's right. How much you have paid? Let us understand.
I was not informed by the lower court advocate. Exact amount I give.
Fighting on that ground only.
But I have
you lost it in, and you don't know how much you have paid. How much you have paid towards that vehicle?
At the time of purchase of the vehicle, I was spent 1,80,000 near about.
Yes.
Thereafter, basing upon one agreement, I was handed over the vehicle to the second party to ply the vehicle and repay the installment. Subsequently, the dispute arose between the parties. And accordingly, I was lodged a FIR before the police. Police seized the vehicle. Thereafter, 2/457 petition was filed. And though
It is allowed in your favor.
that was allowed in favor of the OP number 2.
Acha.
For that reason, I challenged.
Okay, issue notice. Returnable. Yes. Take out the notice. Let us
No,
propose.
I
Yes.
filed for stay operation of the order. As because entire amount he was now take away.
Show me then item 15, huh?
Yes, sir.
49, huh?
49.
49. Show me that you are owner of the vehicle.
Madam, in the FIR itself,
The resident, though is the registered owner of the tractor, but due to financial crisis, he entered into an agreement to hand over the opposite
I was never disputed.
But he has paid some money, not that.
Or what happened, the opposite part number 2 has repaid the entire outstanding bills to the financial. Agree, but the present petitioner.
He is not able to say now how much he is paid.
I can think to change the ownership. Dispute and that. Disputed regarding the agreement, whether that agreement is valid or not.
That can be decided in the civil court.
But I'll say it. I'll stay the operation of impunity. First of all, the criminal case is he should not have filed. See the criminal case. Yes. Yes, sir.
Item 50. Item 50. The 482 application has been filed. His
Yes, sir.
application has been filed challenging the entire criminal proceeding.
Yes, sir.
My lord, may I renew the first hour my learned friend had sought for an adjournment. As Mr. Nanda is to argue.
On the request of land counsel for the petitioner, adjourn it to January 2nd week, interim order to continue.
Item 51.
Right, this is very old matter, 2008
The
matter.
matter has been heard several times. That is the whole predicament, madam. It has been argued. It has been heard several times. Pleadings are complete. Both sides have filed a written note. Everything is ready, my lord.
So Mr. Nando is not there.
Yes, I was also not there, my lord. Since my friend said that.
Since you have come, why don't you argue now?
Well, I need to look less. Somebody must have.
Because I'm a bit reluctant because the.
I understand, madam. I understand. I understand.
Okay, you have personal difficulty and just. Yes.
Item 51.
My lord, may I please your speech? But in this case, your lord says, no? My lord, the petitioners here in my lord, by two petitioners are there.
Against protest petition, cognizance is taken.
On protest, the cognizance has been taken. My lord, though your lordship has already reflected, but noting so that the death certificate of petitioner number 2 has not been filed. Though it is my submission, though it is my submission, your lordship has already recorded also. So against petitioner number 2, it is abated.
After the petition, petition number 2. Can say abated. Yes, in so far as petition number 1 is mentioned, leave the matter on for hearing. It's all right.
My lord.
I
But
take
the-
by your state.
A noting is there. So
Yes. Yes.
my lord.
In
this case,
and now petition number 1 is there. Yes.
Petition confined to petition number 1.
Yes.
Copy this.
Let us come to the protest petition.
My lord.
And
The lordship may kindly see this date chart. I have prepared because that will.
Ready?
not with me. ସେ କହୁଥିଲେ ସେଟା କହିଲେ ଡିସ୍ପୋଜାଲ ବି ହେଇଯିବ ବିକଜ ଆର୍ଗୁମେଣ୍ଟ କରୁ
You tell me.
My lord.
You will
that
withdraw and to argue afresh.
Even I do not know, my lord, what has happened in the lower court. My lord, I am doing one thing. I am submitting a copy to him because it's on police has given a final report. I am submitting a copy to him. let it come any other date, I will also obtain instruction. On that date, if possible, I will withdraw it.
No, if anything still remains, we will see. Otherwise, I'll give that liberty to you. Move a fresh application because there is a change of circumstances.
My lord.
Petitioner number 2 has died. Petitioner number 1 is there.
Your lordship has been pleased to issue notice to appointment number 2. And number of times it is adjourned because appointment number 2 is even not appearing.
He may not be interested also.
My lord. So,
So therefore, in that circumstances, if you move application,
whether this continuance of this proceeding, your lordship, it is going to yield any result or not, that is doubtful.
that's doubtful. So let us see what are the allegations against petitioner number 1. If it is not there, I'll cross here and right.
Your lordship may kindly say the date chart I have submitted.
Yes. Just go, let us have a idea about what are the.
My lord, yes, that the date chart will
yes,
make it clear.
Case number so and so, so and so.
25/11/2012. I lost the FIR.
Meanwhile, just see what is the service position of opposite party number 2.
Sufficient, your lordship.
Sufficient.
Yes. On many dates prior, your lordship has also said that he is not appearing, so for one chance may be given. That is already previous orders also reflects.
24. 24.
To the petitioner. ପୂର୍ବରୁ ଦେଖୁନା ତା ପୂର୍ବର ଅର୍ଡରଟା
Then your whole case is the Vichitrananda Panda and Ramesh Pandey.
My lord.
Those 2 persons preliminary statement.
My lord.
Is the basis of basis of the cognizance. Basis of the cognizance. They are entangled earlier with you.
My lord, I have lost first FIR 25/11/2012. It is charge sheeted. Thereafter, 7 days after they lost the present FIR out of which this protest arises 2/12/2012. That is final reported. In the final report, the police has specifically stated that is an occurrence happening in the middle of the village. That is page 25-27. Your lordship may kindly see. Eta tikya again diyo. Eta tikya legible copy nahi. Mo ete type copy de doche. Page 25 and 27. Eta tikya dekhantu.
Yes. Yes.
Mo debi dabi. Mo debi.
The case.
Because 16 order cognizance under selling. Now in the meantime, 8 years already lapsed. In the latest,
You get the information. Let us.
Today I'm serving a copy.
You say serve the copy. Because there may not be anything.
No, I'm serving a copy.
Status. You get the status and see. Let us see what is the age of the opposite party. 40 years. 2016 matter. No, there was an interim order. So,
not been extended for
interim order has been operating since 2016 onwards. नहीं आगुरु interim order चलीची.
Continue होची.
Continue होची. So therefore the status will be the same. Status will be the same. And do one thing. You serve opposite party number 2 through the IIC. Through the IIC meantime. Through IIC, which police station is this?
Pipili.
Pipili. Opposite party number 2 be served through IIC Pipili. Pipili. Pipili lease the matter on certain day. You leased it on 19th. 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 Extra copy. Give the extra copy. Interim or to continue.
May I please, Your Lordship? I am in BC, my lord. Whether I am audible, my lord? May I please, Your Lordship? my lord. In this
Yes.
case, previously, this case has been heard by coordinated bench, and that has been the matter has been heard in part, and entire episode has been concluded before my lord Justice Sibo Sankar Mishra. This is a case, my lord, where the present petitioner is assailing the order of taking cognizance. Simultaneously, my lord, a department proceeding has been initiated on behalf of the investigating agency. Investigating agency IO is the marshalling officer, my lord.
Yes.
After producing the entirety of the document as collected during course of investigation, my lord, before the department authority concerned, and he has been examined along with the witnesses, those who have been cited as witnesses in the charge sheet, my lord, in during course of investigation, the authority come to a conclusion that he has been exonerated from the charges and department proceeding, that they have come to a conclusion there is no TA. And it has been prima facie found that there is a dereliction of duty because I have not intimated to the authority concerned as per the service code of conduct by rules that I have acquired with fees and other things, other things. I have annexed that I have produced.
When those matters are listed? 9th. I'll list this matter on 9th. Similar matters I am hearing, a group of matter. Exoneration in the departmental proceeding, and what will be the impact of those exoneration in the criminal case?
My lord, to that extent, my lord, I am taking a 1 minute by my lordship. There are two types of department proceeding. One proceeding, department proceeding, there is some dereliction, there is allegation against the person authority concerned, then department proceeding. A person who has been involved in criminal case, the investigating agency initiated the proceeding before the authority concerned. Accordingly, department proceeding has been initiated. That is the judgment of the casual. Your lordship knows that, your lordship, while in this side cited that judgment. And so also this Supreme Court judgment, my lord, that is Minaketan Pani, and so also Pushparaj Das, my lord. In both the cases, it has been held that if the marshalling officer is the author, the investigating agency, and after producing the entirety of the document before the authority concerned and adducing his evidence, then if the authority concerned come to a conclusion that the prima facie there is no case, then one source of evidence is there, and that has been produced by the investigating agency, and that evidence which is a part of the investigation, my lord.
Okay, 9th.
And interim order is there, my lord.
9th, what will happen 9th to?
Interim order
in those matters, pass entry, any interim order.
ମୋ case interim order thila chali jaji band continue କରୁଛି.
You move application.
That is there, my lord. Initially that has been, that is the only interim order to cut.
Interim order cut. Continue.
Okay, yes.
Item 53.
Yes, sir.
306, cognizance has been taken on section 306. And we recollect that my
306.
30, that page 13, cognizance order.
13.
Order of cognizance at page 13.
13, okay. Yes. 306.
Yes. Last occasion, 3 affidavits have been filed. That has been affidavit filed by OP number 2. Informant is flag P.
Flag?
Flag P.
P for
Puri.
Yes. This is one. What are the other materials which has come on record? Okay. Apart from the statement of the informant, who now turn around and say that by misunderstanding I filed it. Apart from that, what are the other materials which has gone on record?
So also kindly see page 28.
20?
Page 28.
28. Because initially the FIR was registered on
No,
302.
That's why I said.
302.
Yes.
After investigation 306.
Yes, that's why.
And what are the material they collected?
Yes, your lordship can
Yes.
see page 28. That's why I said kindly see page
28.
28.
20.
28. 28.
Wait, yes.
Just not
Yes.
2 lines below. Starts from that para starts from eyewitness. Got it, my lord?
Yes.
The eyewitness Vinod Kumar Malik and Vikas Malik, such and such, who have seen Abhinash the deceased, Abhinash Paital Musa, while escaping by jumping wall of the police station, have been examined. My lord, got it? 2 eyewitnesses have seen while you were escaping from the police station. Next para. The villagers of Harijan Sai have also been examined, who have proved that IAS himself and other PS staff soon after escape of Avinash Paitar sought for him along with villagers but failed to apprehend him. Next para. Joint family members where Avinash Patel was found hanging over examined. During examination, the number of family have also identified the rope used for hanging to be their own rope used for farming. Lordship can straight turn to page 29.
Yes.
Page 29, third paragraph, last line. The nature of hanging could be suicidal.
Yes.
And Lordship kindly see last paragraph. So during investigation so far, it has come to the light that Abhinash Patel was arrested and Mahakar PS case no ethic under section such and such. The Abhinash Patel was assaulted by IIC official categories who fled away after being assaulted and has committed suicide in the double-story building of
Honorable Executive. This shall I put it on Monday?
next week.
Monday, Tuesday, anytime you take next week. You seek instruction and tell me.
Yes, yes.
That's the best course, I think.
Correct.
In the because see, this informant also, the informant is liable to be prosecuted if it is correct. He makes allegation against 302. Local police investigated. It was transferred to crime branch. They've investigated. Today he is turning around and say that no, it was a false case. Is it not a case for prosecution? If you allow me to write a judgment, I'll make sure that he is also prosecuted. At least a case should be registered against him. This is a very serious case. So therefore, put an end to it. I'll fix the trial, timing of the trial and seek instruction next week.
Yes.
Next week. Let us take it up on 6th.
6, 7, any day.
6th. 7th. Okay. Seek instruction, advise your client. That's better, right? Yes.
Item 54.
Yes.
My lord. In this case, your lordship, the petitioner challenges the proceeding that is domestic violence case initiated against the brother-in-law. I am the brother-in-law, your lordship. Now, so far, as on date, your lordship, the opposite party has filed a case under section 498A much prior to this against the husband, father-in-law and sister-in-law.
Yes.
Therein, all of them were acquitted.
You were absconding.
I was not even one line stated against me, not a party in affair, not in charge sheeted, never there. My role was entirely not there in the affair, which is lost 4 months prior to this domestic violence case. I was not there at all. That also they faced and acquitted. Now, in the meantime, your lordship, the husband has initiated a divorce proceeding. That divorce has also been allowed. Now,
Now what, whether she is still interested to prosecute you? Still interested?
This is domestic violence case he has initiated.
No, she is still interested.
That is, your lordship, very unfortunate. My prayer is that.
Yes, sir.
My lord, my prayer is that.
The husband, you couldn't do anything to the husband. Husband is let off.
But domestic violence, protection under domestic violence case is still pending, my lord. So far as
let
GR
them-
case is concerned, self-some allegation, my lord. GR case has been he was not charge sheeted, my lord. Police is not charge sheeted, but others were charge sheeted. Thereafter, it was acquittal, and that is against that I have assailed before this honorable High Court, my lord. And that
He was not an accused there.
No.
He was accused there, but no charge sheet was filed against him.
But have you filed protest petition?
No, man.
Then you let him go.
My lord.
Insofar as that case is concerned.
Yes. So far
In
concerned.
section 12 petition, what will you get against him?
Man, so far protection, I have filed petition. Only protection under section
My lord,
12.
Show me your application under section 12.
that is Annexer 1.
Annexer 1, man.
What is the relief you are seeking against him?
Not against him, against the husband.
So let it continue. My prayer is that.
Continue with that.
Yes, your lordship. Yes, my lord.
Continue. But what the, see, come to the relief part.
Yes, my lord.
If you are asking anything, any relief against him, I can understand.
No matter.
So far, when this.
That is my prayer, your lordship. Let the petitioner go. Let him continue with the domestic violence proceeding against the husband and husband, your lordship. That is pending. I have even not made part. Petitioner is husband is not the petitioner. So let it continue. That is my prayer, your lordship.
No, I can't say that they will continue in their absence.
No, husband is not the petitioner, my lord.
I know, but if he can make a statement, I'll continue then.
Yes.
Unless and until domestic violence is proved, I cannot get relief under section 18, 19 and.
No, what are the allegations you have made against him? Let us see in the.
Only allegation is that he was along with the husband, man, and they are also torturing me. Only that part is.
Show me in the petition.
If your lordship permit me.
Omnibus allegation will not.
Yes,
be,
your
no?
lordship.
3, my lord.
3, okay. Yes.
Last. The respondent accused in unparliamentary language in the name of the parents of the complaint aggrieved person. The respondent told that they are not pleased with the.
Who respondent? There are 4 respondents.
4 respondents. All the respondents.
All you don't say that.
No.
Have you said that respondent number 4 is doing this?
No.
Then
No specific evidence.
Then?
All the respondents were.
Then you simply say that insofar as respondent number 4 is concerned,
Right.
I don't want to press
No specific.
section 12.
No.
Then he is out.
My lord, yes.
Yes.
No specific allegations.
Shall I record it?
Your lordship, my
petition, man.
Yeah, my prayer, your lordship, that your lordship, in view of this development of these two, divorce and divorce and 498 acquittal, your lordship may direct that let it continue against the husband, that is domestic.
I will not continue.
No.
Their absence, I can't say that.
No, my lord.
They
Against
may
this,
come and no case is made.
Against-
Once
yes,
I
yes.
say, then it will prejudice.
against this,
I can very well say there is no specific allegation and
Yes.
specific relief sought against respondent number 4, who is the petitioner in this case. So therefore, section 12 is dropped.
resultantly, your lordship, that is exactly, yes, your lordship. That is that.
I can say.
At the Rohila seat.
Then you proceed against them. Isn't it?
Okay.
Petitioner is seeking quashing of the DV miss case number 44 of 2021 pending in the court of SDGM Sadar, Cuttack, initiated by the opposite party under section 12 of Prevention PWDV Act so and so. The petitioner has been arraigned as respondent number 4 in the said petition. Mr. Mishra and counsel for the petitioner submits that what is this divorce is also granted.
That is, I have submitted, my lord. Divorce is also granted.
Yeah, the
That was
petitioner,
also preferred matrimonial.
your
is also-
brother-in-law.
Brother-in-law.
Petitioner is the brother-in-law of the opposite party. Mr. Mishra and counsel for the petitioner submits that the opposite party had initiated a criminal petition against her husband and other-in-laws.
No, not brother-in-law. Father-in-law, sister-in-law. I was not
husband,
accused.
father-in-law and sister-in-law.
My lord.
And they face the trial.
Him also, my lord. against him also.
No.
He was no charge sheet.
I understand it.
Mine.
Criminal case against her husband, father-in-law, and sister-in-law, as well as the present petitioner. However, after investigation, charge sheet was only filed. Charge sheet was filed against the husband, mother, father-in-law, and sister-in-law, and dropping the name of the present petitioner. The said criminal case was eventually in the said criminal case, all the accused persons have eventually got acquitted by the court of JMFC Salipur, by its Judge Salipur in trial case number 259 of 2017 by the judgment dated 30/1/2017. The husband of opposite party number 2 had also filed civil proceeding number 139 of 218, seeking dissolution of the marriage. The family judge Cuttack, by the judgment dated 18/6/2024, has allowed the said civil proceeding, dissolving the marriage between the opposite party number 2 and her husband. Mr. Mishra and counsel for the petitioner submits that the proceeding initiated against him by opposite party number 2 is liable to be quashed on the basis of the development which has unfolded in between. Apart from that, perusal of the complaint under section 12 of DV Act also reveals that neither any specific allegation is made against the present petitioner, nor any relief is sought against him. Therefore, I am persuaded by the submission made by Mr. Mishra. Accordingly, the DV proceeding initiated by opposite party against the present petitioner is quashed. I have not, it is made clear that I have not made any dismissal of this present petition shall not prejudice the right of opposite party to proceed with the DV case qua the other respondents. Other respondents in the DV in the section 12 petition.
Matter has been filed, but that should be mentioned. It will be right.
Appeal has been
filed and matrimonial appeal has been filed.
And she did a acquittal and divorce. Counsel for the respondent, however, submits that against the order of acquittal and the judgment by which judgment of the family court, the opposite party has already filed appeal which are pending in the court.
Before this order.
Yes.
Yes.
Item 55. Wait, please. My lord, the present petitioner in judicial custody since, my lord, 3 August 2022.
Your appeal?
No, my it is against the order of 167 subsection 2, my lord.
Yes.
After 2 years, the police submitted charge sheet after filing of this CRLMC application.
Yes.
So default bail is there, my lord. Within 180 days, they have not submitted charge sheet. But
you are in custody since?
My lord, since 31st July 2022, in PS case number 289 of 2022. There is 2 PS case, my lord. Your lordship may kindly.
In 2 cases you are there.
My lord. No, I am before. In this case, my lord, there is only 1 case. But what matter is, lord, 31st July 2022, the same IO forwarded me in the case number 289 of 2022 and 3/8/2022, he remanded me in this case, my lord. Since 3/8/2022, I am.
In this case, you are in custody.
3/8/2022.
3/8/22.
My lord.
3/8/22. Okay. This is PS case number?
PS case number, my lord, Sundargarh PS case number 224 of 2022.
224 of 22. Yes. Yes, tell me.
My lord. They've submitted charge sheet.
What are the other petition, second one?
Another matter here, same another issue, Your Lordship. Your Lordship directed on 3/9/2024. Order of this Honorable Court. May kindly glance.
3/9?
3/9/2024. Your Lordship directed, considering the Mohammed Darbaz versus State of NCT of Delhi, the petitioner will approach the learned court below if for interim bail. That also rejected, my lord.
Interim bail is rejected.
Because they are saying, my lord, I have criminal antecedent. I have 10 number of criminal antecedent, similar to NDPS matter.
Yes.
But my lord, in this case, Your Lordship, I am before this Honorable Court for default.
What about the other cases which are pending against you? You are on bail.
On bail, Your Lordship.
Yes. Yes.
Further, my lord, in this case, my lord, they submitted charge sheet on 8/8/2022.
8/8?
2022.
Okay. Yes.
My lord, everything is there in the rejection order.
No, the issue is something different. Now, criminal antecedent, nothing. What he's trying to say is, Mohammed Darbaz, he is relying. He says that the charge sheet, preliminary charge sheet is filed. Chemical examination report is not filed. So, in the Mohammed Darbaz and all other petitions, and including the judgment of this court, it says that he is entitled for interim protection. Entitled to, because till you file the chemical analysis examination report. If you have not brought, once you bring the chemical examination report, then on the basis of that, it will be reconsidered. But till you file it, he is entitled for interim bail. Have you filed it or not? For that purpose, because the interim bail is granted only for the period till you file the chemical examination report, the antecedent will not come in the bill. Because 37 of bar will not operate.
On that point, I will. Already, my lord, filed since.
He is in custody. You have to simply tell me whether chemical examination report is placed on record or not. What is your instruction?
My lord, so far my instruction, my lord, they have not submitted yet. But my lord, in the first CRMC, my lord, they filed charge sheet without naming my name, my lord. They filed preliminary charge sheet on 8/8/2022. My name is not there, Your Lordship.
That is
they filed charge sheet against me in the year 2024. After 2 years, not within 180 days, my lord. After 2 years, they filed against me. That's why I am relying, my lord, Thaluri Chakravarti, this honorable court.
But you have relied on, see, the order dated 3/9/2024.
Because, my lord,
you have relied upon Mohammed Darbaz.
Mohammed Darbaz, because, my lord, in this matter, they are taking time and time, my lord. Your Lordship may kindly peruse the orders. 25 May 2024, 23rd May 2024. That's why I am praying, my lord. I am also considered within the Mohammed Darbaz. Let the learned court below release me on interim bail. That also rejected, Your Lordship. This matter not finalized, Your Lordship.
You seek instruction within a week. Because his liberty is at stake. If he is entitled. If he is not entitled, then I'll put it on
7.
29. 7th. No. Put it on 9th. 9th. Okay.
The C report part is in the second CRLMC, my lord. The C report part is in the second CRLMC. If the present CRLMC is considered and Your Lordship will pass the order, then that is infructuous.
Obviously.
My lord.
Yes. So we will concentrate on the first one.
In the first
1626.
Yes, Your Lord.
1626. Yes.
Grateful, my lord.
56.
Mr. Mahapatra, can be taken up next week. He is on accommodation, my lord.
What are you seeking, madam?
My lord, I don't have the file. He just.
I'm for the opposite party, my lord. It's the case of 138 of NI Act. At the stage of evidence, after closure of evidence of the complainant, she has the accused has come up before this honorable court challenging the maintainability. On the ground that check has, company has not been made a party,
wherein check was issued by one of the director. But my case is check was issued admittedly that accused person is a director of a company, but check has been issued in her personal capacity.
Show me in the complaint where have you said that.
My lord,
Otherwise, the complaint has to fail.
yes, that I know. If company has issued a check, then
On behalf of the company,
no, not on behalf. I have highlighted my date check and my
not date chat. You show me the complaint. I don't want to go to the pleadings.
No. In my date chat, I have annexed the.
Come to the complaint. What have you said in the complaint? Let us see. And show me the notice under 138 and the complaint. Simple. I need not read anything.
And I don't have leave to address, my lord. Let it come next week. He'll come.
Let me see it. You need not address it.
That is in the.
The story will come forth on the basis of the complainant.
That is in the petition annexure 1.
Yes, let us see where what you said. Which paragraph?
Page 17, my lord. Internal page 3.
Yes.
Paragraph, sorry.
Who owes the money? Company owes that?
No. Background of the case is that accused is somehow is a college friend of this complainant. She was a director of a company. She wanted to sell some of her land to the complainant. And she asked me to deposit money in his company account because she wanted some deposit some money in her company account. So accordingly, I have deposited money in her company account. Then she executed an agreement with me for sale of her land. But she failed to execute a sale deed. Then she refunded my money on her own account.
Show me the notice.
My notice he has not annexed, but I have annexed in my description, my lord.
Yes, give me.
That is my date chart.
So give me the notice, copy of notice, what date chart will do.
That is, I have filed, but I am.
Where is that?
Giving it.
Page 16, Roman 2. Roman 2 in between. Read it.
The 16 of
complaint. Accordingly, as per the instruction of the accused person, the complainant transfer rupees 20 lakh to the business account for the accused person. That is account number so. This is the company. And you have given the amount to the company.
Yes, my lord.
And check is issued.
Check has been issued by her in her personal
account.
Personal account.
Show me in the notice.
I'm showing
the notice.
Check, my lord. There are two cases.
Have you filed the reply?
I filed a date check to that. Entangle all my
show me document. Date chart will not help, sir, unless you show me the.
And she has also partly paid me before the court below. Out of 20 lakhs, she has paid me 35,000. And also ordered to before the court below that she will clear up all the dues within a short period. Then she came forward before this honorable court below.
The sale deed was executed in whose favor? Company favor or individual?
No. Sale agreement to sell.
Agreement to sell.
She has executed for on her individual capacity. She has executed that agreement to sell in my
The
favor.
only thing is the money was paid in the
Money
company
was
account.
deposited in the company account on her request. But she returned that money, issued that check in her individual capacity. And in that extent, I have also get decisions that even if amount has been paid to the company, if the check has been issued by the individual capacity.
Madam, you don't have a case.
Lord, I don't have the case, I don't have the file, I don't know about.
Who is appearing in this
But
matter?
Mr. Devidatta Mahapatra is the petitioner counsel.
See, he has taken entry model and in a 138 matter
Today he is an accommodation.
tomorrow.
My lord,
Tomorrow.
tomorrow he will come and.
See, there is an agreement entered into between the this accused as well as the complainant. And in the agreement, it is very specifically, she is a signatory to this. She has said that transfer the money in the account of the company. But the entire dealing is between individual dealing.
And on the last
Merely because the money deposited on your request in his account doesn't mean that the company's liability. Liability is a personal liability.
It come tomorrow.
Liability is a complete personal tomorrow. I'll vacate the stay or dispose of.
On Monday.
Monday I'll change my mind. I'm with you today. I'm with you today.
My lord.
Okay, Monday is all right. Monday.
Let the interim order continue till tomorrow. He'll come and.
Till Monday it will continue.
Interim order is there that he will file an application before the court. I am not going to move it.
Place this thing on record.
I have already placed, my lord.
It is not on record, therefore you just verify it. Just verify it today. I'll take it up Monday. Okay.
Already, my lord. This is my office copy, so.
No. Please verify whenever you file that.
I have filed it long back, my lord.
But it is not attached with this file.
I filed it in 11th line.
Okay, verify in the registry. Verify.
I'll have another 2 copies on that.
Yes. Okay, next.
Item 57.
57 is
same, my lord.
56, 57, huh? Monday. Make it. Monday will be very tough.
Tuesday.
Make it Wednesday.
4th.
Oh, nice one. Grateful.
Yes.
Item 58.
Yes, sir.
My lord, in this case, I am a brother-in-law, Jedusra, filed a questioning the affair by way of a compromise. The husband, my lord, opening number 3 already appear and file the Mata case number 261 by 2024, compromised by the division bench and permanent alimony, wife is already received. In the condition, already filed, my lord, that is it.
3 lakhs ଦେଇଛନ୍ତି ଆଉ ସେଟଲ ହେଇଯାଇଛି ହେଇଯାଇଛି କିନ୍ତୁ ଆମର ଯୋଉ ବେଡ୍ ଆଉ ଯୋଉ ଡାଇନିଂ ଆଉ ଯୋଉ ଡାଇନିଂ
ସେଟା କିଛି compromise ରେ ଆସିନି?
ସେଟା
1 minute.
ଆମ
My lord, annexure compromise, sir.
1 minute. Let me understand. He is the brother-in-law. You have to take money from the husband, na? You leave him. You keep on collecting money from your husband. It is settled between you and your husband. Permanent alimony will be given by your husband only. He is the brother-in-law.
ହାଉସଫୁଲ ଆର୍ଟିକଲ ମୋର ଯୋଉ ବେଡ୍ ଥିଲା ଆଉ ଯୋଉ ଡାଇନିଂ
ଆମ ସୁନା ସେ ନେଇଛନ୍ତି କଣ ବେଡ୍ ଫେଡ୍ ସେ ଦେଇଛନ୍ତି ସେ କହିଲେ ଆମେ କିଛି ଦବୁନୁ କି ଦବୁନୁ ଆମର
ଆପଣଙ୍କର dispute solve ହେଲା କି ନାହିଁ? ହେଇଗଲା ନା?
order, my lord. Annexure.
Where is he?
Annexure.
Are you opposing? Are you opposing or what?
No.
Can I be permitted, Lord, in this case,
Yes.
Lord? There no doubt matter has been settled amicably and in matrimonial appeal, the judgment has been passed reflecting that all the parties will withdraw their respective cases by
Yes.
virtue of this judgment. We have no objection because this case which has been sought for quashing was initiated by the wife, me. I have no objection, let it be quashed. But
Where is matrimonial appeal order?
My lord, that is a annexure objection by the counterfile by the husband, my lord. Running page 4 and flag A.
I have already received the permanent alimony.
Forget it, you collect it. bad and not.
ବେଡ୍ କଥା ସେ କିଛି କହିନାହାନ୍ତି ଆମ ସୁନା ବି ନେଇଛନ୍ତି ଦେଇନାହାନ୍ତି ସେଟା ଛଡା ହେଇଯାଇଛି ସବୁ।
କିଛି ମୁଁ ତ କିଛି
Petitioner-
ଦେଇନାହାନ୍ତି ବାହାର କରିଦେଇଛନ୍ତି ମୁଁ କଣ ନେବି ବୋହୁ କଣ ଘରକୁ କିଛି ନେଇକି ଯାଏ କଥା ହଉଛି କଣ ସବୁ ଜିନିଷ ମାନେ allow କଲେ
ସେ ଶାଶୁର 3ଟା ଗହଣା ନେଇଛନ୍ତି ଦେଲେନି ଆମେ ଛାଡ଼ିଦେଲୁ।
Oh, only one bat is there. Why don't you give it?
କୁଆଡେ ଗଲାଣି ସେ ଆମେ କଣ
ଗୋଟେ
କରିବୁ?
ବେଡଟା ଗୋଟେ ସୋଫାଟା ଗୋଟେ ଡାଇନିଂଟା
ଏ ପୁଣି ସୋଫା ଆସିଲାଣି ସୋଫା କୋଉଠି
ବାହାଘର କେବେ ହେଇଥିଲା? ବାହାଘର କେବେ ହେଇଥିଲା?
ବାହାଘର ହେଇଥିଲା ମାଇଲ ଏ ଯୋଉ 2022
ବାହାଘର ମାସ 2 ମାସ ପରେ ସେ ବାହାର କରିଛି
2022
2022 ଥିଲା ଖଟ ଦେଇଥିଲେ petitioner is the brother-in-law.
ଟଙ୍କା ନେଲ ବା
Petitioner is the brother-in-law of opposite party number 2. At opposite number party number 3 is the husband.
My lord.
Huh?
My lord.
Are you sure?
My lord.
Opposite party number 3.
Already appear through advocate ଓକିଲ ତାଙ୍କ ଚିହ୍ନ କରିଦେଇଛନ୍ତି।
I am asking something, you answer it. Opposite party number.
Rajesh Kumar Behra.
Opposite party number 3 is the husband of opposite party number 2. Next up. Because of the matrimonial dispute between the opposite party number 2 and 3, the FIR number so and so was registered. Arraigned the petitioner as one of the accused. The parties have the opposite party number 2 and 3 have settled their dispute. And eventually, the settlement terms was 1 minute. Where is that? Eventually the matrimonial appeal being a matter number 261 of 2024 was allowed by the division bench of this court, taking into consideration this settlement terms. The order dated 21/11/2024 passed by the division bench of this court in matter number 261 of 2024 reads as under para 3 and 4. Pursuant to the said settlement term, the opposite party number 2 has already received the permanent alimony. Hence, the dispute has dispute between the petitioner, opposite party number 2 and 3 has been put to rest. On the strength of the said settlement term, the petitioner, who is the brother-in-law of opposite party number 2, has filed the present petition seeking passing of the FIR being Sukinda PS case number 121 of 2024, corresponding to CT case number 237 of 2024. Heard Mr. So-and-so for the petitioner and so-and-so for opposite party. The aforementioned position regarding the settlement has not been doubted by either party. Rather, conjointly they submit that both the parties are bound by the terms of settlement. In view of Mr. So-and-so appears for the state and submits that the dispute being primarily arising out of matrimonial discord, and the parties have settled their dispute in judicial proceedings, which is reflecting in the judgment of in the order of the division bench of this court. There is no legal impediment in quashing the FIR. Regarding head to the aforementioned, the FIR number so and so is quashed. Yes.
Item 59. May I please, madam? Well, I am submitting on behalf of Mr. Sarda Prasad Das.
Yes.
Well, this is the application for releasing of the vehicle. The application of the present petition has been rejected by the revisional court. And initially, before this application, the petitioner approved this honorable court. This honorable court, observing all the facts regarding two decisions of this honorable court, division bench as well as single bench, directed to reconsider the release of a vehicle to the revisional court.
Where is that order?
My lord, that order is annexure 2, my lord.
Yes. Yes.
And the pursuant to that order, although the two decisions did not take into consideration the law and additional district judge, and mentioning another judgment, reject my application. Hence, again, I approach this honorable court.
No. Come to the impugn order, page annexure 3.
My lord.
Annexure 3.
Annexure 3, that is the subsequent rejection order. After remand from this honorable court.
That is what you are challenging. That order, the Sessions Court has considered.
Yes, ma'am.
Consider Ashish Ranjan.
Ashish Ranjan is considered another, not considered, and referring another judgment, single judgment of a single bench of this honorable court, rejected my application. I have also taken that up.
No, para 3 also.
Yes, ma'am.
Ashish Ranjan, it is reproduced also.
Para 3.
Para 5.
No, he has mentioned in the para 5 to the last portion.
Apart from Ashish Ranjan, the other matters also, other judgments also considered. Yes.
That is single judgment of this honorable court, so far as the concern, but that judgment, so far as the observation is concerned, that is considered. In this honorable court granted release that vehicle, considering all the facts.
Yes.
So that part I have not considered.
Have you seen, madam?
Yes, madam. No, that judgment I have not seen. I want to just submit one thing, my lordship. That time the confiscation was not been started. Now it has been started, which the honorable court has written in their judgment, my lordship.
Okay.
May I please,
This is for interim release only.
My lord.
Yes, my lordship, but my lordship kindly have a glance.
What is the stage of confiscation?
My lordship, in the last para it was written.
Initial stage. Only notice has been issued.
By the time the petition to release the vehicle was filed in the court of Learned JMFC Nimapada, the confiscation proceeding of the seized vehicle has already been initiated. Hence, in view of the observation of the Honorable Court, in the case of Silas Mutili, Section 72 of the Odisha Excise Act is a bar and court cannot entertain any application.
It says that once confiscation proceeding starts,
yes,
then the bar operates.
Yes,
if you have not initiated confiscation
Yes,
proceeding, then in that case interim relief can be given. That's
the act also saying that, my lordship.
I am my lord has also granted relief to the opposite party where the state has come before this honorable court. That is one of the landmark.
No, in that case, confiscation proceeding
Yes,
is
yes,
initiated.
Yes.
My lord, sir,
My
another
lord.
judgment by this honorable court that in honorable court in Manjulata Bhuyan, which was the judgment was passed on 8/1/2024. Manjulata Bhuyan versus state.
The vehicle is confiscated in which case?
My lord, so far as that case, my lord has decided.
NDPS case.
There is here is about 52 Excise Act.
52 excises.
Excise Act.
Then 72 you believe.
My lord, and so far as particularly 52 Excise Act has been dealt by this honorable court, my lord Justice the coordinate bench has categorically stated and directed to release the vehicle. Although I was appealing for the state, I opposed, and that was a grant release of bail. My lord, I am submitting that judgment. Because Ashish Ranjan Mahanti and my lord will know about
get the stage up for the confiscation. Let us see. What is the stage?
so far,
I'll put it after 1 week. I'll see.
My lord, what happened?
What is up for confiscation proceeding?
Another thing is that, my lord.
I understand it.
Yes, my lord, can you give me a glance to
There are conflicting views.
This judgment.
My lord, I also
No, I am
one judgment is there by this honorable.
There are conflicting views.
I am holding one judgment. My lord, can you give me a glance?
When you are that side, you are holding some of the.
I have given that judgment. I know. I have given that judgment, my lord.
Yes.
Paragraph I have made highlighted. My lord, gone through.
Yeah.
Till then, this honorable court granted the considering the judgment of a Supreme Court.
My personal view is if confiscation proceeding final order is not passed,
Yes.
you are entitled
Yes,
for
sir. My lord judgment is there.
entitled
I have
for
handed over.
interim relief,
Yes, sir.
interim release. If confiscation order is passed, you have to
So do some resubmit the vehicle.
that's my view.
That is my lord's.
Let her get that status after 2 years.
My
Issue notice.
no, my lord already issue notice.
Acha, acha.
Already.
Mr. Maharana is directed.
Last occasion, this report directed for issue notice.
Maharana is directed to obtain the present status of the confiscation proceeding.
Yes.
Yeah. Positively by next date of hearing.
My fix a date, my lord.
Date I'll fix.
What happened? Initially, that was
I'll tell you.
and that
The date would be
the
on
vehicle is
19th.
going to be
19th December. 19th.
my
Yes.
obliged.
Yes.
Item 16.
Please, your lordship.
Yes, sir.
This is an appeal against conviction. Charges were framed under section
Ready.
13.
So, all previous comments there. Okay, not okay. Till then I have to stand by the order of the action judgment and.
Have they said anything thereafter hostile or simply hostile? I don't know anything.
Till then I would like to request your lordship to observe. And either you, if you at all, you decide either of you. Without going to make the details. What I say, it's a public draft. And a public servant was put to custody, demanded on the allegation that he had demanded money are given and so on. He given 164 statement before the magistrate. And now at the trial stage they are turning hostile. In this situation, to avoid this sort of situation, you also have to, what I like to observe, request to also give an observation. That in that case, the complaint should be pushed. So that
They are your officers. Many of them.
No, complainant.
As a complaint. Okay.
complainant has to, in that case, please say that not a question.
No. In that case, I tell you, if I will acquit him, and he has a right to prosecute for malicious prosecution.
The public servant there.
No, suppose I will make an observation. Then if he files a suit for malicious prosecution, that the defendant in that suit, the complainant, who will be the complainant, he will be prejudiced. He will be prejudiced.
This thing is that he, what he is saying that, he is saying that because 181 and 182 can proceed. Subject to your lordship's order.
No, I understand it.
Would you fair and way in respect of genuine prosecution?
You give me some judgment if those kind of observations find out something, I'll do it. Because malicious prosecution is for damages. He can proceed against him. But this man who has done, he should be prosecuted for giving false evidence and all.
He may file a suit for malicious prosecution.
That's it.
So, for 181, 182 is concerned, we can proceed against.
I'll record it that it will not preclude the prosecution to proceed against him. That I can do.
This prosecution should be avoided. And the genuine cases, they will not turn hostile.
Yes.
That is that's not.
Milord, I'll file a written note. Your lordship may pass orders. I'll file a written note. I am also filing a written note.
Shall I put it on 7th?
Milord, your lordship may reserve the orders. I am filing my written note. Let him also file. There is nothing as such, my learned senior place. Why unnecessary will be kept on board? Lordship
You will get rid of it and the liability will come on me. That's what you want to say. There is nothing in this matter what to do.
Therefore, I am doing.
I'll reserve the judgment you give your written note.
I'll file the notes today. I'll serve him a copy today.
And all evidences are there?
Yes, Milord. I have given a detailed note in my.
It won't be a bigger judgment also. There is, and I need not deal with any evidence because there is no witness.
My note is 18 pages. I leave it to your lordship.
If there is any evidence, then only. There is no evidence what to do. You get some judgment so that I can make observation. He can prosecute, you can file a suit for malicious prosecution. You are subjected to.
I was a OIC.
But then he is entitled to do.
The complainant
Yes,
was
yes,
involved in the case.
This sort of genuine prosecution should be protected and malicious prosecution should be that is the.
You give me that portion, I will observe it. While recording in acquittal, I will say that it will not preclude the prosecution to proceed. No, consider, obviously. Why should you consider?
May I permit to make a mention? Item 54 of the wiki list, 2010 vigilance matrimonials. So Lordship may fix a Lordship, larger Lordship, Lord fix of any day, Lordship, finally, only 10 minutes like
Date is already here.
Yes, Lord, I have already prepared the written notice submission. 2010, it was pending, Lord.
I'll check it up at fixed date. Huh?
Lordship, I will.
To make a mention. Weekly list item 138 and you will taken up on Monday.
Monday, why do you presume that I will not take it up? I will take it up on Monday. Monday it will be